good to go. Hold on one second.
Okay, are we ready to go?
It's loading the live stream. Give 1 second here.
And I can release your video order.
Okay, you're good to go.
Okay. And anything about the live stream you're taking care of, right?
Correct. Yep, that's all done.
Okay, the court will come to order. Are the parties ready for trial?
The prosecution is ready, Your Honor.
Okay, thank you.
The defense is also ready.
I'm sorry, did the defense say they were ready too?
Yes, Your Honor. Sorry.
Okay. I have a list of things to do, so forgive me as we go through this. It looks like we have a copy of the trial roster and team's code. If there are video recorders present and being used, have both teams given approval for that?
Yes, the defense has, Your Honor.
Okay.
Prosecution has as well, Your Honor.
Okay. So I take it there are no objections to taping of the round. If there are, I guess speak now. It's my understanding as well, the Colorado Bar Association may be taking photographs of the competition and using it. And I guess by participating, you're granting permission by the Bar Association. Anyone in the gallery who's connected with teams not competing in this round, meaning the student members, coaches of other schools or the same school but a different team, should leave the courtroom. Apparently there are exceptions. If you think that applies to you, see Rule 4.3. The team should be reminded that no recesses will be allowed, except for a health emergency, and especially not between the end of a witness examination and closing arguments. We handled the conflict issue. Teams and coaches are reminded that any disputes arising out of the competition must be reported in accordance with the competition rules. The teams are also reminded that their compliance with time requirements will be considered in their scoring individual performances. No coach or team member, other than a timekeeper, is seated in the jury box, but I think that rule really doesn't apply today. If the people could introduce their participating team members, please, both attorneys and witnesses.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Nicole Gutierrez. I will be delivering the opening statement. I will also be directing Jordan Markowitz and crossing Avery Becker.
Good afternoon, Your Honor, ladies and gentlemen of the jury. My name is Anushka Udeshi, and I'm an attorney for the prosecution. Today, I will be directing Kyle Kuzak and cross-examining Taylor Perkins.
Thank you.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Annie McDonald, and I am an attorney for the prosecution in today's trial. I will be conducting the direct examination of Alex Fuentes, the cross-examination of Blake Van Allen, as well as performing the closing statement for today's trial.
Thank you. And if we could hear from the defense as well, please.
Good afternoon, Your Honor, opposing counsel and members of the jury. I'm Greta Batchelor, attorney for the defendant Avery Becker, who will be appearing virtually today via Zoom. I'll be performing the opening statements, conducting the direct examination of Taylor Perkins, and the cross-examination of Kyle Kuzak.
Thank you.
Good afternoon, Your Honor. My name is Sana Kennedy. I am the attorney for defendant Avery Becker. I will be directing Avery Becker and crossing Alex Fuentes.
Thank you.
Good afternoon. My name is Maria Cook for the defendant Avery Becker, who is appearing on video via Zoom today. I will be conducting the direct examination of Detective Markowitz, the direct examination of Blake Van Owen, the cross-examination of Detective Markowitz, and the closing arguments.
Thank you.
Good afternoon, Your Honor. members of the jury and opposing counsel. My name is Alexandra Williams, and I am Avery Becker in today's case.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Katie Jack, and I am Taylor Perkins.
Good afternoon, Your Honor, members of the opposing counsel, and ladies and gentlemen of the jury. My name is Cassie Kulig, and I am Blake Van Owen.
Thank you. One thing I would ask before we get started in earnest, everybody's speakers and microphones are a little different. There were a couple people that were a little hard to hear. Please talk loud, project, pretend you're filling your courtroom. Obviously what you have to say is important and we want to hear it, but just doing everything virtually makes it a little hard. So please keep your voices up as much as you can. I think at this time I need to swear in the team members, the gallery, the scoring panelists, and the witnesses. So if everybody involved in this would stand for swearing in, and this is in an effort to maintain the level of professionalism and to uphold the code of ethical conduct during and after these mock trial proceedings. All members of the gallery, scoring panels, and team shall stand for the swearing of the oath of ethical conduct. Team members, please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and the rules of mock trial competition? I didn't hear anything from anybody, so I know everybody is on mute. If anyone has an issue with that oath, please let me know, or otherwise I'll assume you all took it. Okay. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of mock trial competition? Okay, I'll assume again, because everybody is on mute, that nobody has an issue or a problem with the oath. If they do, please let me know. Gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And again, no responses. And again, I will assume that everyone's okay with the oath. And if you're not, please let me know. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with facts, procedures, and rules of mock trial competition?
I do.
Thank you. I just needed to know that my speaker was working.
Yeah, I do.
Thank you. So with that, we will, I guess, begin the trial in earnest. Before we begin, are there any pretrial matters?
Yes, Your Honor, I would like to discuss pretrial matters, if that's all right with you.
Certainly, Ms. Gutierrez.
All right, the prosecution asks that all stipulated facts be entered into evidence.
Any objection from defense?
No objection, Your Honor.
Okay, stipulated facts will be admitted.
All right, and we would also like to ask that when instructing witnesses to look at exhibits, that they may look at the trial packet when instructed to do so.
I'm sorry, can you say that again?
When instructing witnesses to look at exhibits during direct or cross-examination, that they may look at their trial packets, whether it be on another tab or on paper, that they are allowed to do so.
Okay, we talked about this a little bit in our orientation. Apparently, you guys have the ability to share your screen and show everybody the exhibit. My guess is this is kind of the step before that, where you're just showing your witness?
Yes, Your Honor.
Okay.
All
that
right.
works for me if it works for the defense.
Yes, Your Honor. However, we would like to ask that evidence be displayed on the screen prior to motions for admission.
I think we can, in the world we live in now, constructively understand that sharing your screen is showing it to your exhibit to your witness, and it is not admitted and shown to the jury unless it's admitted and published. Okay. Anything else from the people?
Yes, we would also like to ask that when exhibits, oh, well, we already covered that. I was going to say that when exhibits are admitted into evidence, the co-counsel may publish to jury by screen sharing. I think that we already established that though.
I'm sorry, say that again?
That when exhibits are admitted into evidence, that co-counsel may publish to jury by screen sharing.
Certainly. That's
right. Sounds good.
not a
And
problem.
during the closing, the prosecution also requests that we can reserve time, some closing time for a rebuttal.
Yes.
Right. And we also ask that the timer may remain with their camera on throughout the whole duration of the trial, just so we can see the timestamps during direct and cross-examination.
I don't have a problem with that. Anything from the defense on that issue?
No objection, Your Honor.
All right, that concludes pretrial matters, Your Honor.
Thank you. Anything from the defense?
Yes, Your Honor. We ask to remain seated during examinations of our witnesses.
Certainly, given that we're doing this virtually.
We also ask that we turn our cameras off when our witnesses aren't being examined.
Not a problem.
All right, great. That's all from the defense. Thank you.
Okay. Do the parties have anything else before we start with openings?
No, Your Honor.
Okay. We'll first hear from the people for the prosecution opening, please.
I will be giving the opening statement, Your Honor. All right, I will begin. Your Honor, members of the jury, have you ever been betrayed by someone you trusted? Have you been stabbed in the back by someone you considered a mentee, a student, a friend, someone you believed in? We are here today because of the murder of a deceased Mackenzie Brackman, who was brutally murdered in the doorstep of his own home. But before we get to the gory details and the witnesses present here today, I'd like to paint you a picture. We have a mock trial coach committed to helping every single individual on his mock trial team become astute lawyers in the courtroom. This team, however, would consume more of his own time than his actual job as an attorney. This coach was Mackenzie Brackman, and he would spend countless hours getting his Colorado high school mock trial team ready for the state competition, and he would also get them to an impressive competitive level, which allowed the team to move on to the state competition successfully. Despite his wonderful efforts, there was one member on the team that wasn't entirely happy with Mackenzie Brackman's role as the coach. This person is our defendant, Miss Avery Becker, a supposed natural at high school mock trial. Miss Becker became angry with Mackenzie Brackman, angry with Mr. Brackman's overtness towards her lack of effort to put in actual work for her so-called passion for mock trial. However, Mr. Brackman allegedly robbed Avery Becker's opportunity as a senior to win the Best Attorney Award at the state competition by kicking Miss Becker off the team for vandalizing his car. Acting in rage, Miss Becker attempted to trash Mr. Brackman's home, but instead ended up killing Mr. Brackman in a fright when finding him home on the day she was only supposed to trash his residence. Thus, desire and vindication were Miss Becker's motives. To achieve this, she aimed to trash Mr. Brackman's residence, committing second-degree burglary, and killed him as a source of escape, qualifying as first-degree murder. Today, with the help of my co-counsel, we are here to prove that Avery Becker did in fact kill Mackenzie Brackman beyond a reasonable doubt. You will first hear from Detective Jordan Markowitz, who will walk you through the crime scene, being Mr. Brackman's prior residence, and highlight specific details attached to the residence itself. And then she will verify Miss Becker's various locations during the time of the murder through call detail records. Kyle Cusack will then expand on Markowitz's description of the crime scene and go through each piece of available evidence to explain an overwhelmingly convincing theory of how the murder likely occurred. And the final witness, Alex Fuentes, will collaborate on Miss Becker's actions during her time on mock trial before she was kicked off the team, describe the time he saw her at the Fry Shack the day before the murder, and show us valuable texts between him and Avery Becker that prove she was going to trash Mr. Brackman's residence. Today, the defendants will present witnesses as well, in addition to Avery Becker. Miss Becker's best friend, Taylor Perkins, will attempt to confirm Avery Becker's alibi on the day of the murder. However, all that will be revealed is her inherent bias for her friend and Miss Becker's obvious hatred for Mackenzie Brackman. Lastly, the wonderful Blake Van Owen that will feed you a twisted replica of the theory of the prosecution without offering actual information to corroborate her theory. While the defendant's side will seek to instill doubt in your mind on Avery Becker's role within the case, the motive and evidence connected to Avery Becker is the sole proof that Avery Becker did in fact kill an unfortunate Mackenzie Brackman. In addition to this, the defense will attempt to turn the storyline of the case into fiction, making you believe that another person is guilty for the murder of Mackenzie Brackman. These theories may make you rethink the definition of a reasonable doubt. But for clarification, a reasonable doubt is defined as a doubt based upon reason which arises from a fair consideration of all the evidence or a lack thereof in the case. Thus, if you as the jury find from the evidence that each and every element of the crime has been proven beyond a reasonable doubt, you must find Avery Becker guilty of the murder of Mackenzie Brackman in the first degree. Thank you.
Thank you. Does the defense wish to make an opening?
Yes, Your Honor. Ladies and gentlemen of the jury, Your Honor, today you will see how the detectives in their investigation have cut too many corners. This investigation started off as a square, a blank canvas. But as the investigation went on, the detectives have cut so many corners that what you see here today is a circle, one big hole. The prosecution has already told you some of the experts in this case, but we will show you just how they took shortcuts and made rushed assumptions. This is a tragic, tragic crime, a crime that Avery Becker did not commit. And this investigation has cut so many holes in itself that it has allowed the true killer to escape prosecution. Let me start off by introducing Avery Becker. She went to Colorado High School last year. She was on the mock trial team, and she was very good at what she did. But she didn't get along with the coach. You probably have quite a few questions about Avery, and you will see them answered today. But I can tell you right now, is Avery a perfect student? No. Is Avery a perfect person? No. Is Avery always calm and happy? Again, the answer is no. But does that mean she's any less human? We've all been angry and been a little bit too quick to act. She was mad and felt she was being treated unfairly, and she made a rash decision to take a marker and draw on a car. But that does not make her a murderer. She may have made that one mistake, but her only mistake was being an unruly teenager. She knew what she did was wrong, and she was trying everything to apologize. She knew the consequences of that mistake. After all, she'd been kicked off of the team that she loved so much. So why would she want to repeat her same mistakes again if she knew the repercussions? These are some of the questions we will be asking today. We will show you how Detective Jordan Markowitz, also known as Chief Corner Cutter, failed to investigate other suspects, even though there are other questionable characters in this case. We will question Alex Cifuentes, the rival of Avery on the mock trial team and a friend of another potential suspect. We also question Kyle Kuzak, a crime scene expert who made some questionable assumptions when investigating the crime scene. But today you will get to hear from Avery herself. You will see in her what the investigation has failed to see. A young girl who made the mistake of being angry and grabbing the wrong marker. You'll hear straight from her where she was. And we will ask Taylor Perkins, a friend of Avery, where the two of them were that fateful day. You will hear about the alibi that the detectives and opposing counsel have failed to investigate or even consider. We are going to show you evidence about how this investigation was conducted improperly, including testimony of an expert witness who knows how crime scenes should be investigated. There are also key pieces of evidence in this case that lack proper explanation or reason to them. The murder weapon, a large chef's knife, was found on the scene and was automatically assumed to have belonged to the victim simply because it might have fit into a knife block. This is strange for many reasons, the first of them being that there are a pair of large scissors next to where the victim was sitting if he had wanted to defend himself. And this knife matched no other knives in the house, even though there's a clear pattern that most of the knives were part of a set. You might be thinking, why is it so important where the knife came from? And this is a key piece of the crime scene that the police failed to properly investigate. We are going to show you how someone with a motive to kill Mr. Brackman brought the knife to the crime scene with the intent to kill him that day. We will be introducing a possible suspect today, someone the police failed to investigate. Our suspect is the son of a former client of Mr. Brackman's who is out for revenge. We have him on tape even saying so. This person was also absent from school the day of the murder, and he would have known where Mr. Brackman's house was. This person is friends with Mr. Cifuentes and could have potentially gained access to Avery's phone to frame the murder on her. But this is another corner cut in the detective's investigation. After all, they were so lazy, they stopped looking for suspects after Avery. It is important to remember that in this case, there's zero evidence putting Avery herself at the crime scene. There is no one who saw her there, no video footage where you can identify her. There's evidence of her phone near Mr. Brackman's house and suspicious photos of supposed screenshots from a teenager's phone claiming she was going to the crime scene. But that is all circumstantial, and since the police failed to investigate Avery's alibi, they have no way to refute her and Taylor's statements. This case centers around a few key hours where someone broke into Coach Brackman's house and intentionally or unintentionally killed him. But it couldn't have been Avery because she was at the mall with her best friend searching for her lost cell phone. Unfortunately, the police didn't even consider this. They didn't even consider a lot of things. They just cut so many corners that you will not be able to tell what is fact and what is assumption. This investigation tried to shove Avery into this crime. They tried to put a square peg in a round hole. You'll ask yourself many questions today, but I would like to ask one right now. Can they prove beyond a reasonable doubt that Avery was the one who broke into the house and killed Mackenzie Brackman?
Thank you. I'm going to pause for just a few seconds so the scoring panel can finish what they're doing. The prosecution's first witness.
Yes, Your Honor, the prosecution calls Detective Markowitz to the stand. All right.
And
Your name for the jury, spelling the last for the record.
Jordan
sorry?
Markowitz. I'm sorry?
Before we get started, Detective, can you raise your right hand? And I'm going to ask that all witnesses on both sides raise their hands since they're all present, I believe. Do you swear or affirm that you will swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I'm sorry, counsel, you may proceed.
No worries, Your Honor. All right. Please state your name for the jury, spelling the last for the record.
Jordan Markowitz, Markowitz.
So, Ms. Markowitz, what is it that you do for a living?
I'm a homicide detective with the Denver Police Department.
And how long have you been a detective?
7 years now, and I started with the DPD 13 years ago.
As a detective, do you have any specialties?
Yeah, I specialize in anything to do with cell phones. So specifically, I'm certified by the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
What did you learn through this training?
I learned how to obtain and analyze cellular records and cell tower data, and how to use forensic software to download information from cell phones.
Have you ever actively used this training during your detective work?
Yeah, all the time. I've had to download the contents of literally hundreds of phones, and I've obtained and interpreted cell tower data in over 50 cases at this point.
Your Honor, at this time, I move to admit Detective Markowitz as an expert in cell phone technology and forensic data recovery.
Defense?
May I voir dire the witness briefly, Your Honor?
Briefly, yes.
All right. Good afternoon, Detective Markowitz. You've been a detective for 7 years, correct?
That's true.
And the only specialized training you've received is in cell phone technology?
Yeah, that's what I'm an expert in.
And you've never testified as an expert before, have you?
I don't believe so, but I don't think that's important.
You've never testified as an expert in cell tower analysis before?
I do have extensive training in the topic. I don't see why
This is a yes or
I
no
should be able
question.
to testify.
But you've never testified as an expert in cell tower analysis, yes or no?
I have not.
And you've never testified as an expert in forensic evidence, have you?
No, I have not.
And you don't regularly analyze forensic evidence in your work as a detective, do you?
I'm just an expert in cell phone technology and forensic data recovery.
All right, Your Honor, the prosecution has not provided the sufficient foundation to enter this witness as an expert in anything except for cell tower data or cell phone technology.
Any response?
Your Honor, I believe that we have already established my witness's experience with cell phone technology and forensic data recovery, as she has had years of experience prior to this trial to testify today in court as an expert in cell phone technology and forensic data recovery.
I agree. The objection will be overruled. I understand the objection, but based on the witness's specialized training that is not common to most people, she'll be allowed to testify and render her opinion under 702. Please proceed.
Thank you, Your Honor. All right, Detective Markowitz, I'd like to turn your attention to the case. How did you become involved in the investigation?
Sure, we received a report that the victim, who we later identified as Mackenzie Brackman, was deceased just inside the front door of his house. I was assigned to investigate his death, and I arrived at the scene around 2:20 p.m.
What did you first notice about the crime scene?
When I arrived, the front door was open and the gate to the backyard was unlocked. You could see Mr. Brackman lying just inside the front door of his residence.
Can you tell me more about the victim?
It was clear that he had been stabbed. We found him face down in a pool of his own blood. There was a large knife next to his body and a wound in his left shoulder. From the angle of the body, it looked like the intruder had stabbed him while he was trying to leave his home.
How were you able to corroborate the fact that there was an intruder?
I actually noticed that there was a Ring camera at the front door. Just so the jury's aware, Ring cameras are cameras that act as motion detectors and record activity outside the home. The footage showed an intruder entering the house.
Were there Ring cameras anywhere else?
There were 2 other Ring cameras. While I was walking around the outside of the home, I saw a Ring camera aimed at the gate to the backyard and another camera aimed toward the back door.
And how did you obtain these video recordings?
It was actually quite easy. I got access to Mr. Brackman's phone and I downloaded the information. He was actually paying a monthly fee to keep access to recorded events, so I could access the footage from March 6, 2020.
All right, so if I showed you a Ring video related to the homicide, would you recognize it?
Yes, of course.
Your Honor, may I have permission for co-counsel to screen share what has previously been marked as Exhibit 12?
You may.
All right, Detective Woods, did you take a moment to review these videos? I mean, did you recognize it?
Yes, this is one of the videos we collected from the Ring camera footage.
Is this a fair and accurate representation of the footage you reviewed?
Yes, it is.
How do you know that these videos accurately show what happened outside of Mr. Brackman's home?
Like I said, because Mr. Brackman paid a monthly fee for the cameras to download recorded events onto his phone, there was no third party involved and no one besides Mr. Brackman and the police had access to it.
Your Honor, I now move to admit Exhibit 12 into evidence.
Defense?
No objection, Your Honor.
Okay. 12 will be so admitted.
All right, Detective Markowitz, what is depicted in this video, just to clarify for the jury?
The intruder goes through the backyard and enters the house.
Is there anything else important about this video?
Yeah, there are actually 2 important details for the jury to note. First, the intruder is the same height and build as the defendant. And second, the Halloween mask shows that the intruder had criminal intent, i.e. they masked their identity because they planned to do something illegal.
Moving on, you mentioned that you downloaded the contents of Mr. Brackman's phone. Did you find anything else relevant to the investigation?
I actually found quite a few texts and emails related to something called mock trial. Apparently, Mr. Brackman was a high school mock trial coach for Colorado High School.
What did you do with this newfound information?
I reached out to the school and I obtained contact information for all the students on the team. And one of the students, Alex Fuentes, was actually able to identify a potential suspect, Avery Becker.
Can the defendant please turn on the camera so Detective Markowitz can identify them?
Counsel, if you'll have the defendant turn on the camera, please. Thank you.
Just so the jury is clear, you do see Avery Becker in the courtroom today, Detective Markowitz.
Yes, they are the person in the glasses and the black blazer.
All right, thank you. What information, you can turn your camera off now, Miss Avery Becker, thank you. What information did Mr. Cifuentes give to you?
He sent me screenshots of text message conversations between Miss Becker and himself showing her intent to trash Mr. Brackman's home on March 6th.
All right, so knowing this about Miss Becker, what did you do?
I tried to have Miss Becker come in for an interview, but right before the interview, I received a call from Miss Becker's lawyer saying her client would not be coming in and communication
Hearsay.
only go through the attorney.
I'm sorry, counsel?
Objection, hearsay. In the testimony, the witness talked about the Becker's attorney calling her and mentioned something, an out-of-court statement that attorney made to her.
Response?
My witness is here and present to testify on the veracity of this statement, Your Honor.
But there is no statement. Right?
Well,
You mean a statement from the witness, the attorney?
yes, my witness is here to corroborate the fact that she got a call from Becker's lawyer. So.
Okay. That objection will be sustained only as to the part of getting a call from the attorney and what the attorney said as hearsay, as well as commenting on the right to remain silent. Please proceed.
All right, I understand, Your Honor. All right, so after Miss Becker did not come in for her interview, what did you do next?
I obtained a warrant to search Miss Becker's phone, but it turns out that she had conveniently lost her phone the day before the murder, or so I was told. So I was still able to access Miss Becker's account records and cell tower records through her service provider.
And what are cell tower records?
Cell tower records can help you pinpoint someone's location based on the cell towers their phone connects with. They're technically call detail records, so when you send or receive a call or text, a record of that interaction is created. Additionally, a cell phone is constantly reaching out to find cell towers it can communicate with, even when it's not in use. So if you can access all the cell towers in an area, you can pretty accurately pinpoint where someone was.
So what specific information does a call detail record provide?
It provides a lot of information. It shows the date and time of the communication, whether it was incoming or outgoing, the number the phone was in communication with, whether it was a call or text, and it identifies the cell tower the phone communicated with, including the direction of the antennas. But it does not provide the content of the communication.
And how does a cell phone choose to connect with a specific tower?
Most of the time, it will connect to the tower near it. However, it is a little bit of a complicated algorithm, so sometimes things go a little wonky and it will connect to a tower farther away.
And how do the call detail records help in your investigation of Miss Becker?
We found that Miss Becker received several calls and texts from Miss Taylor Perkins leading up to Mr. Brackman's murder. And we also found that Miss Becker traveled from her house towards Mr. Brackman's home, arriving there around the time of the murder.
Objection, speculation. The witness cannot testify to Avery's location, but simply the whereabouts of her phone.
Response?
You said that it was speculation, correct?
Yes.
Can you say why it was speculation again? I'm sorry.
Yes.
If you could repeat the objection, please.
Yes, Your Honor. The objection is speculation because the witness cannot speculate to Avery's location, but can only testify to the location of her phone.
Right, okay, so my witness is an expert, therefore she has room to speculate on this matter, Your Honor, and she is speculating on the cell phone, on the location of the cell phone. So we can perhaps assume that Miss Becker did have her cell phone and she was near her cell phone at that time.
Okay, your witness is an expert, so it's entitled to give opinions. And counsel, I think that, or Ms. Cook, counsel, defense, I think that is something you'll be able to bring up on defense, whether she knew where she was versus her, just where her phone was. So I'm going to overrule the objection for now. Thank you.
All right, Detective Markowitz, just one more time so we can restate the question. How did the call detail records help in your investigation of Ms. Becker?
And you're on mute, ma'am.
You're on mute.
Oops, my bad. We found that we were able to trace several calls and texts from someone named Miss Taylor Perkins, and we were also able to trace Miss Becker's location through her phone, finding that she arrived at Mr. Brackman's house around the time of the murder.
Were you able to record the cell tower data?
Yes, I actually put together a diagram of all the information.
So if I showed you that diagram, would you recognize it?
Of course.
Your Honor, permission for co-counsel to screen share what has previously been marked as Exhibit 16.
You may.
All right, Detective Markowitz, I'm now showing you what has previously been marked as Exhibit 16. Do you recognize it?
I do.
All right, what is it?
It is the diagram with the call detail records.
All right, and is this a fair and accurate representation?
Yes, it is.
Your Honor, I now move to admit Exhibit 16 into evidence.
Response?
No objection, Your Honor.
Exhibit, I think you said 16?
Yes.
Will be admitted.
All right, Ms. Markowitz, can you please give a brief description of what the diagram shows?
It shows the locations of the cell towers that Ms. Becker's phone communicated with on March 6th in the time leading up to the murder. The antenna on each cell tower have a 120-degree arc, so we can see Ms. Becker's location in relationship to the cell tower as well. The exhibit also shows a possible route that she took towards Mr. Brockman's home.
Based on the map and the CDRs, where was Ms. Becker before the murder?
Objection calls for speculation.
All right, I will rephrase the question, Your Honor. I'm sorry. Based on the map and CDRs, what does the first cell tower show?
Ms. Becker received a text from Ms. Perkins at 12:47 p.m. that went through cell tower 12273, so they were likely near or at their home.
And what was the second cell tower that Ms. Becker's phone communicated with?
Ms. Becker received another text from Ms. Perkins at 12:55, and it went through cell tower antenna 11911, located on Rock Creek Parkway, traveling towards Mr. Brockman's home.
What's Rock Creek Parkway?
Looking at the map, Rock Creek Parkway is the primary street which connects the homes of Ms. Becker and Mr. Brockman.
All right, and what was the last cell tower that Ms. Becker's phone was in communication with?
An incoming phone call came from Ms. Perkins at 1:05 p.m. and another at 1:06, and finally a text at 1:17. The last communication went through cell tower antenna 1197, which means that Ms. Becker was likely near Mr. Brockman's house around the time of the murder.
Okay, so just so the jury is clear, what does all of this indicate?
It indicates that Ms. Becker was at home somewhere between 12:45 and 12:50, then left, drove towards Mr. Brockman's home, went along Rock Creek Parkway, and at 12:55, then from 1:05 to 1:17, Ms. Becker was at Mr. Brockman's house.
All right, and how can you tell when all activity on a phone stops? I'm sorry.
When a phone is turned off or it's placed in airplane mode, it will stop communicating with the cell towers near it.
And did the activity on Ms. Becker's phone ever stop?
The records show that all activity on Ms. Becker's phone ceased after 1:20 p.m. on March 6, 2020, which showed that Ms. Becker turned her phone off after the murder, or they destroyed and disposed of it later.
All right, no further questions, Your Honor.
Examination.
Yes, Your Honor. Good afternoon, Detective Markowitz. I'd like to begin by talking about your conclusion of a scuffle at the crime scene. At the crime scene, you noticed drops of blood on the floor, correct?
I did.
And you took photos of the blood spatter with a digital camera?
Unfortunately, they did get lost. That's why I didn't testify.
They became corrupted, weren't they?
Yes, they did. That's why I didn't testify about
And
it.
you were never able to recover them, were you?
No, I was not.
The jury will never see these photos.
No, again, that's why we didn't talk about it today.
All right, you also claimed to notice that Mr. Brockman's home was in disarray.
Yes, it was.
But you couldn't tell if that was just the normal state of the house, correct?
I mean, I normally don't find homes looking this messy,
But you've never been to Mr. Brockman's home prior to the murder, correct?
I'm sorry?
You've never been to Mr. Brockman's home prior to the murder, have you?
No, but I would assume that dishes wouldn't be broken on a regular basis.
Never seen pictures of Mr. Brockman's home prior to the murder?
No, I don't know who takes random pictures of their house.
You also noticed that a chair was knocked over.
Yeah, it was.
And you can, Your Honor, may I share my screen to present what has been previously marked as Exhibit 9?
You may.
Great. Detective Markowitz, can you see this?
Yes, I can.
Do you recognize this?
Yes, this is one of the photos that we took of the crime scene.
And is it a fair and accurate representation of a photo you took of the crime scene?
Yes, it is.
Your Honor, the defense moves to enter Exhibit 9 into evidence.
Ms. Gutierrez,
No objection, Your Honor.
Exhibit 9 will be admitted.
All right, may I proceed?
You may.
All right, there's no knocked over chair in this photo, is there?
No, I don't see it. It must have been out of the frame or something.
But there aren't any other photos of the crime scene.
No. I don't know why this is important.
You can also see a pair of scissors in this photo, can't you?
Objection, Your Honor, relevance.
May I respond?
Please.
Your Honor, this is a photo of the crime scene. I'm asking the detective to recount their observations of the crime scene, which include any sharp objects near Mr. Brackman, near where Mr. Brackman would have been sitting.
The objection will be overruled. The witness
Great.
can answer.
Would you like me to repeat my question?
I think I answered it.
Okay, your investigation didn't take the presence of these scissors into account, did it?
Let me tell you something. I've been investigating crime scenes for 7 years now.
This is a yes or no question.
People do crazy things when they're in danger. It's quite likely that Mr. Brackman just wasn't aware of the scissors.
So Mr. Brackman wouldn't have grabbed the nearest sharp thing to him?
People get scared. They do crazy things. They're not thinking logically.
All right, so you also noticed scuff marks on the floor, correct?
I did.
And you don't know if the scuff marks were on the floor prior to the crime?
No, I don't.
And you also noticed several expensive items in Mr. Brackman's home left undisturbed?
Yeah, again, Avery was
including a
likely to get
laptop?
back at him. So I don't think she would steal. She'd be well off.
But you saw a laptop undisturbed at the scene?
Yeah, I don't know why Avery would take
You saw several flat screen TVs undisturbed?
Again, the motive of the crime was likely emotional. Avery
that a
wasn't
yes?
intending to steal anything.
Is that a yes to my question?
Yeah, there were flat screen TVs. If anything, that shows that there was no outside criminal. It was just emotional intent.
So I'd like to talk about how your investigation led you to Avery Becker as a suspect. You spoke with another student named Alex Fuentes during your investigation?
I did.
Who just happened to be the first student you called?
Yeah, it was pretty fortunate. They were
And
able to
he sent you screenshots of a text conversation between himself and Becker?
They did.
But you never saw the phone this conversation was on, did you?
No, unfortunately, I did not.
Because Fuentes forgot to bring their phone to the interview.
Yeah.
And you never downloaded the contents of the phone, did you?
No, like I said.
And you've downloaded the contents of hundreds of phones, right?
So I know when someone's lying and when I actually need to download those contents.
All right, let's talk about your analysis of the cell towers. You claim to be able to track Becker's location at the time of the crime using these cell towers?
Yeah, we can accurately find out where her phone was, and she was
But if a lot of people are using their cell phones in a particular area, a phone may connect to a further away tower, correct?
It's extremely rare for that to happen.
And cell tower records aren't a GPS.
No, they're cell tower records. The GPS is different.
The cell tower records also showed that another cell phone was sending texts to Becker's phone?
Yes, it does. I think we talked about
And
that.
Becker's phone never answered these texts?
No, because she was murdering someone.
And you never found Becker's phone, did you?
No, like I said, it was likely destroyed.
All right. You are aware of Avery's alibi, aren't you? And that Becker was with Taylor Perkins?
Yeah, kind of convenient
that they were both at the Fry Shack in the mall?
Sorry?
That they were both at the Fry Shack in the mall, correct?
Yeah, that's what they say, but...
And you didn't interview any of the employees at the Fry Shack, did you?
Objection on irrelevance?
May I respond?
Please.
I'm asking the witness about their investigation and asking if they investigated the alibi. Considering that Avery claims to be at the location during the time of the murder, I'm asking for the witness to explain their choice to not investigate any of the witnesses at that location.
I think how the detective investigated or didn't investigate, given her conclusions, is relevant, so it'll be allowed.
Right. I'll repeat my question. You didn't interview any of the employees at the fry shack, did you?
I'm sure if the defense wanted that information, they could have interviewed those employees themselves.
Can you answer my question?
I did not interview them.
You didn't interview the motorist that initially reported the body, did you?
No, they were just someone who saw a dead body. I don't know why I would interview
You
them.
never considered any other suspects in this case, did you?
Sure, I actually say in my statement, I consider that it could be an ex-client as well, but the evidence showed otherwise.
Okay, so you didn't consider Cifuentes a suspect?
I've been analyzing crime scenes for 7 years. I
This
think
is
I
a
know.
yes or no question.
There is no reason to consider Mr. Cifuentes as a suspect.
And you're also aware of Mr. Brackman's career as an attorney?
Yeah.
You didn't investigate any of his former clients?
Again, I go where the evidence takes me, so if that doesn't lead me to clients, I'm not going to jump to conclusions on my own.
And you're aware of another student at Colorado High School named Blair Rollins, aren't you?
Objection, relevance.
I'm sorry?
Objection, Your Honor, relevance.
Response?
Yes, Your Honor. The relevance will become clear when the defense presents their case, but this is an alternative suspect that the detective never investigated.
Overruled.
Right. So you're aware of another student at Colorado High School named Blair Rollins?
There are thousands of students at Colorado High School, likely.
This is a yes or no question.
Yeah, sure. Blair Rollins.
And you didn't investigate Blair Rollins, did you?
I did not.
Thank you, Your Honor. No further questions.
Any redirect?
No redirects to Your Honor.
May this witness be excused.
Yes, this witness may be excused, Your Honor.
Okay, thank you. Detective, you may step down. If the people would call their second witness, please.
Your Honor, the prosecution calls Kyle Kuzak to the stand.
Having been sworn, you may begin.
Thank you. Now, Ms. Kyle Kuzak, please state your name for the jury, spelling the last for the record.
And you're on mute, I'm sorry. It happens
Sorry.
all the time. That's okay.
My name is Kyle Kuzak, Kuzak.
And Ms. Kyle Kuzak, what is your current job?
I am a certified crime scene reconstruction investigator with the Colorado Bureau of Investigation.
And how many years of experience have you had?
I've been working 19 years with investigating complex crime scene. My most recent 3 years have been with the city of Denver.
Wow, that's a really long time. What type of crimes do you investigate?
I tend to investigate home invasions, burglaries, other property crimes, homicides, and occasionally armed robberies.
And how are your years of experience related to this case?
I have a lot of experience investigating homicides and burglaries, which is exactly what happened at 44 South Flower Street, which is the victim's residence.
Your Honor, I move to admit Ms. Kyle Kuzak as an expert in crime scene reconstruction and complex crime scene analysis.
Defense?
No objection, Your Honor.
Okay. Kuzak will be admitted as an expert in, I'm sorry, crime scene reconstruction and what else?
Complex crime scene analysis, Your Honor.
Okay.
Thank you, Your Honor.
That as well. Thank you.
What are the guiding principles in your work, Ms. Kuzak?
I approach my work with 2 principles. First, I assume that every case is going to trial, and so I conduct a comprehensive and thorough investigation. Secondly, I materialize, document, and organize all the evidence in a manner that may allow future reconstruction of the crime scene.
And how do you approach a typical crime scene?
Conduct an accurate and efficient flow of my CSR work. I follow 5 CSR steps. I approach every crime scene with first, recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction.
And how did you start your investigation at the victim's house on 444 South Flower Street?
I approached this crime scene as I would any crime scene with my 5 steps. For the first step, I made a witness tracking spreadsheet to help summarize key points of information of witnesses and suspects. And then I drew a timeline to help with the key chronological and physical relationships in this crime scene. The pages that I submitted pages of my CSR report that have this content.
Your Honor, permission to let my co-counsel present their screen, which will display what has previously been marked as Exhibit 17.
You may.
And do you recognize this document, Ms. Kuzak?
Yes, I do.
And what is it?
This is the CSR report that I submitted for this case, showing the witness tracking spreadsheet currently on screen. And if you scroll down a little bit, it will also show the timeline I drew with the chronological relationships.
And is this a fair and accurate representation of your CSR report?
Yes.
Your Honor, I move to admit Exhibit 17 into evidence.
Defense?
No objection, Your Honor.
Exhibit 17 will be admitted.
Thank you, Your Honor. And after step 1, how did you proceed for steps 2 and 3 of this case?
For steps 2 and 3, I first prepared the materials for a formal analysis and put all the evidence, such as the ring security footage and the photos that I reviewed, into an evidence tracking spreadsheet. Organizing all of this revealed a clear chronology of the victim's stabbing pattern.
And what did you do next?
I mean, of course, after step 3 comes step 4, where after I organized all the evidence, I conducted a formal analysis looking at key evidentiary relationships, identification of event segments, and sequencing to develop a hypothesis. And lastly, I had others review my work to make sure I properly organized this, as this is qualified as a complex crime scene.
And earlier you mentioned some photos. Could you please elaborate?
Yeah, so the photographs I reviewed were simply just a couple of photos about blood splatter. They showed blood cast off on the wall and ceiling near the front door. Like I mentioned before, these showed a clear chronology that the victim was stabbed near the kitchen, then proceeded to the front door where the knife was pulled out and dropped. Unfortunately, those files were corrupted after my review, but they did not affect the development of my final theory for this case.
And while at the scene, what else did you observe?
I noticed some scuff marks, a broken dish, and an open knife drawer.
And if you saw photos of these items, would you be able to recognize them?
Yes.
Your Honor, permission to let my co-counsel present their screen, which will display what has previously been marked as Exhibits 7 and 18.
They may.
And we can reference our Exhibit 9 and 18 as they have previously been moved into evidence. We can reference Exhibit 9 as it has previously been moved into evidence, but what does the document which has previously been marked as Exhibit 7 show?
This is a photo of the open knife drawer that I saw at the scene.
And what does the document that has previously been marked as Exhibit 18 show?
It shows, I'll allow the counsel to get there. It's one more below. Yeah, so this shows the scuff marks that I observed at the crime scene near the back door.
And Your Honor, is this a fair and accurate representation, Ms. Kuzak?
Yes.
Your Honor, I move to admit Exhibit 18 and Exhibit 7 into evidence.
Any objection?
No, Your Honor.
Exhibit 18, and I'm sorry, what was the second one? 7?
7.
Will be admitted. Thank you.
Thank you, Your Honor. And Ms. Kuzak, can you please elaborate to the jury the significance of these photos?
Yeah, so I understand that Exhibit 9 has already been previously been admitted into evidence. However, that is a photo of a broken plate, and the scuff marks in Exhibit 18 and the open knife drawer in Exhibit 7 all depict a struggle. In my investigation of this case, I took in account into this evidence to create my theory.
And based on your 5-step process you mentioned before, what did you determine to be the sequence of events in this murder?
So first, I examined the Ring doorbell footage, which captured the perpetrator trying to get in through the front door and then proceeding to the backside of the residence since the front door was not open. And at that point, they passed another Ring security camera. In these videos, it is clear that the intruder was wearing gloves, which is why no fingerprints were recovered at the scene of the crime.
And if you saw these videos again, would you recognize them?
Yes, I would.
And we can reference Exhibit 12 as it has previously been moved to evidence, but what does the footage which has previously been marked as Exhibit 10 show? Your Honor, permission to let my co-counsel present their screen, which will display what has previously been marked as Exhibit 10.
They may.
Now, Ms. Kuzak, what does this depict?
So this exhibit shows the victim trying to enter through the front door of the house.
And is this a fair and accurate representation?
Yes.
Your Honor, I move to admit Exhibit 10 into evidence.
Any objections from the defense?
No, Your Honor.
Exhibit 10 will be admitted.
Thank you, Your Honor. And then what happened?
So as you can see in Exhibit 12, after the intruder, or Exhibit 10, after the intruder tried to enter through the front door, they went through the back door, in Exhibit 12, and after entering the residence, the victim was alerted to their presence, and so the victim grabbed a knife from the knife drawer, seen in Exhibit 7, which was previously admitted, and since the broken plate is 5 feet away from the back door, while the scuff marks are near the back door, both of which also have been previously admitted, I believe that the intruder and the victim started a struggle near the back door and then moved towards the kitchen table where the plate was broken.
And considering your processes and evidence, what is your theory of this case?
My theory is that the physical evidence on the scene has led me to believe one thing. This was clearly a planned burglary gone bad. The intruder clearly had knowledge of the victim's residence and chose to intrude on the residence during a time at which the victim would have been out of the house. Unfortunately, the victim was present and was alerted to the intruder's presence due to the Ring security footage, and in the ensuing struggle, the victim was killed with the very knife that they brought to defend himself.
And why do you believe that this was not a random break-in?
So the intruder was clearly wearing a mask and gloves in the Ring doorbell cameras. This shows that they had planned this breaking and entering with malicious intent.
And are you familiar with Blake Van Owen?
Yes, I do know her. I've met her at several crime scene reconstruction conferences. However, she is just a police officer and was never an actual CSR like myself. She only reviews the work the actual crime scene reconstructants do and mostly draws her conclusions by reading our reports. And today she is here as a witness for the defense.
And what is Ms. Van Owen's theory of this case?
She believes that this was a random sneak attack.
Correction hearsay.
And I'm sorry, can you repeat the original question again?
What is Ms. Van Owen's theory for this case?
Okay, and the objections hearsay. Response, since Ms. Van Owen isn't the witness?
Well, Ms. Van Owen's theory for this case is included in their statement, and it is also for the truth of the matter of this case. So therefore, they have Ms. Kuzak has the right to give her opinion on it as an expert.
But the opinion hasn't been rendered yet in court, right? That would come in the defense case because it's my understanding Ms. Van Owens is a witness, correct?
Ms.
Is
Van
that right?
Owen, witness, yes.
Okay. I'm going to sustain the objection. Thank you.
And one last question. In your expert opinion, who can you conclude is responsible for this crime?
In my opinion, based off of all the evidence gathered at the crime scene, including the ring security footage and other things, they match the perpetrator's height, which is that of the defendant as well. So therefore, I can conclude that the defendant on trial is responsible for the murder of Mr. Brackman.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Let's talk about the alleged murder weapon entered into evidence as Exhibit 6. Did you measure the size of this knife?
No.
And you claim this knife came from Brackman's home, don't you?
Yes.
And you notice a knife block in Brackman's home as well.
Yes, I did.
This has previously been marked as Exhibit 8. Permission to share my screen to show what has been previously marked as Exhibit 8.
You may.
So this knife block has one knife missing, correct?
Yes, that is true.
But the murder weapon doesn't match the other knives in the block, does it?
No, it does not.
And you didn't measure the hole in the knife block, did you?
No, but like I said before, there is a knife
That was
drawer.
the yes question. So you don't even know if the knife that was found on the scene could fit into the knife block?
Well, it could have fit into the knife drawer that was earlier shown in the scene. It had a wide array of knives, so it could have belonged to that drawer.
So you observed this drawer of knives in Brackman's home, correct?
Yes, I did.
But none of them match the brand or the style of the murder weapon, do they?
Like I said before, that is a various array of knives. None of them are even the same model.
But let me repeat my question. Do any of them match the brand or the style of the knife found in the crime scene?
No, but that's the point of a varied knife drawer.
Okay.
Relevance?
Sorry, counsel?
Relevance of the knife, of the brand?
Response?
Yes, Your Honor, I am simply trying to determine through the questioning of this witness the origin of the knife, and the style and the brand is important to determining that.
Any reply?
I don't see the point because my witness has already told opposing counsel that this knife, like in the knife drawer, there was a multitude of different knives.
Well, I guess the jury will decide if any weight is given by this knife not having anything related to it in the knife drawer. The objection will be overruled. Thank you.
Let me
Please
continue.
continue.
You never measured any of the knives in the drawer, did you?
Asked and
No.
answered.
Your Honor,
Answered.
I think she asked about measuring the knife that was found on the floor, not all the ones in the drawer.
Okay,
So
thank you.
that'll be overruled.
let me repeat my question. You never measured the knives in any of the knives in the drawer, did you?
No.
So one of the knives in the drawer could have fit in the knife block?
They could have.
You also never found any DNA on the knife?
No.
You found no fingerprints on the knife?
Like I said before, the intruder was wearing gloves. You could
This is a yes or no question. You never found any fingerprints on the knife?
there wouldn't have been any because there was gloves.
But you didn't test the knife for DNA evidence?
If someone is wearing gloves and stabs another person, the only DNA would be the person who is stabbed.
So specifically, since you didn't test the knife for DNA, you didn't find Avery's fingerprints or DNA on the knife?
I mean, the only DNA would have found would have been that of the victim.
Okay. Let's move on to your use of Exhibit 17, the spreadsheet. This is a copy of the spreadsheet used to organize witnesses, is it not?
Yes.
And in this spreadsheet, who do you identify as the person who first found the victim?
I'm sorry, could you screen share a copy of the spreadsheet that you're talking about?
Yes. Can you see this?
Yes, I can.
So this is a copy, and in the spreadsheet, who do you identify as the person who found who first found the victim?
The motorcycle.
But in the
Sorry, the EMT.
The EMT. But didn't Markowitz say that the person who first found the body was a passing motorist?
I mean, yes.
So your statements don't match, do they?
No.
Okay. So in this interview, it's also mentioned that there are interviews. Were you present for these interviews?
Yes.
Okay. And how many other suspects do you mention on this spreadsheet?
Not many more.
Just Avery, correct? Just Avery and Alex, correct?
Yes.
But Detective Markowitz said that Alex was never a real suspect, correct?
Yeah.
Okay. So Avery was your only true suspect.
It would seem so.
Okay. Moving on, in your analysis of the evidence presented, would you say that you eventually come to what you say is the best explanation of events?
Yes, of course. This is a tried and true method. I use those 5 steps for every single crime scene I analyze. There's no other way to reach the evidence or that conclusion, in my opinion.
And would you say, after reviewing the evidence, that the intruder in Mr. Brackman's house matched the general height and build of Avery?
I would assume so.
But you cannot confirm the specific identity of the intruder based on the video footage and evidence?
No.
So you cannot confirm the intruder is Avery Becker based on purely the video evidence?
Well, considering all of the other evidence, you can draw that conclusion.
About the video evidence, can you identify the person who's entering as Avery Becker?
No.
That will be all. No further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor.
May this witness be excused. Okay. If Ms. Kuzak can step down. And does the prosecution have any other witnesses?
Yes, Your Honor, the prosecution calls Alex Fuentes to the stand.
Okay.
Please state your name, spelling the last for the record. Oh.
You may begin. Go ahead.
My name is Alex Fuentes, Sifuentes.
And can you tell me a little bit about yourself?
Yeah, so I'm a senior at Colorado High School, CHS.
And how would you characterize your involvement in today's case?
Well, I was a member of the Colorado High School mock trial team with my friend Avery Becker, who is the defendant, and Taylor Perkins. And Mr. Brackman was our amazing coach. Just crazy that he's dead.
And what was your relationship with Avery like?
Oh, we are best friends, like the best friends. But like all friends, we've had our issues. We disagree about how to prepare for mock trials sometimes, but other than that, we get along.
And can you tell me a little bit about what you witnessed between Mr. Brackman and Avery?
Yeah, so Mr. Brackman was always telling Avery to prepare better for practice and tournaments, and it really stressed the team out when Avery would just refuse.
How did Avery often respond to these accusations by Mr. Brackman?
Well, Avery seemed to hate Mr. Brackman for this and would always play the victim. Your Honor, I believe that my attorney has frozen. Oh, there she is.
And then was there any incidents that occurred between Mr. Brackman and Avery?
Yes. So their boiling point was crazy. Avery was demoted to the B team after being late to practice again. But then Avery convinced their friend Taylor Perkins to quit the team, which forced Mr. Brackman to bring Avery back onto the A team.
Right. So what occurred after that point?
Well, after that, Avery went and vandalized Mr. Brackman's car by writing worst attorney award on the hood in permanent marker.
How did Mr. Brackman respond to that?
He was very, very betrayed. It was a very grand betrayal, and he felt stabbed in the back. Probably not the best idiom to use at the moment, but and the team thought it was unfair, and we were pretty devastated.
And did Avery ever reach out to you after that point?
Yes, she actually texted me after the vandalism incident because I'm her best friend and asked that I speak with Mr. Brackman for her.
Did you take screenshots of that exchange?
I did.
And if I showed them to you, would you recognize them?
Yes, I would.
Your Honor, at this time, I would like co-counsel to present what has previously been marked as Exhibit 14.
They may.
Could you tell me a little bit about these screenshots?
Yes, these are text messages that were sent between me and Avery the night before, or the day before the murder.
Your Honor, at this time, I move to enter Exhibit 14 into evidence.
Any objection from the defense?
Objection, hearsay.
Your Honor, may I respond?
Please.
Under Rule 801D2, this is a statement being made by opposing party, and therefore opposing party can testify to the veracity of this statement. As well, these are statements made by Mr. Cifuentes, and therefore he can testify to the veracity of those as well based on his reasonable perception of the texts.
Thank you. Any reply?
No, Your Honor.
I agree. These are statements of a party opponent as a from the defendant. They'll be allowed. Thank you.
So could you please read what is stated in the last couple of texts?
Yeah. So after I said that Avery, or after I said I could go talk to Mr. Brackman for Avery, she says, well, if he's still upset about his car, he's gonna be really upset what I do to his house. And then I asked, what are you gonna do to his house? And then she says this, I'm gonna wait until he's at work and then break it and trash it. She says that'll show him.
What did you think about this?
Well, I did not think this was a very good idea, and Avery went into Mr. Brackman's house and killed him.
And finally, do you know a Blair Rollins?
We go to school together, but I wouldn't know her well enough to say hello or goodbye in the hallways.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Fuentes. My name is Sanaa Kennedy, and I'm representing Avery Becker. You were friends with Avery Becker, correct?
Oh yes, we are best friends.
And you're on the Colorado High School mock trial team with Avery Becker, correct?
Yes.
You would consider yourself and Avery to be good friends, right?
Yeah, best friends.
And Avery is a good attorney?
She wins awards, and she's good at making stuff up on the fly.
All right, good at thinking on the fly for crosses and closings, you said, correct?
Yeah, she's very good at thinking on the fly.
So she won the award for best attorney, isn't that right?
Yes, she did, but the scoring system is inherently flawed.
That was a yes or no question.
Yes, she did win that award.
And that annoyed you, didn't it?
Well, I was a little bit mad just because she didn't prepare as well as I did, but.
Was that a yes or a no?
I said that it did irk me a little bit at the time, yeah.
So was that a yes?
I already answered that question. Yes.
All right. You said she never worked as hard as everyone else, correct?
She didn't seem to be working quite as hard as everyone else.
You also kept bringing up how Avery would always do great on crosses and closings without trying, and how you thought it was unfair and how she lucked out. Is that correct?
Could you repeat that question just a little bit slower?
You also kept bringing up how Avery would always do great on crosses and closings without trying, and how you thought it was unfair and how she lucked out. Is that correct?
Like I said, the scoring system is inherently flawed, and so she won based on multiple panelists liking her performance.
That was a yes or no question.
So I guess that would mean yes.
All right. Let me ask you this. You were at the mall with Avery Becker before the day of the murder. Is that correct?
I was at the Fry Shack I was at the Fry Shack, not the at some point for the murder, yes.
And that was at the mall, correct?
I was at the Fry Shack.
Which is located in the mall.
Yes.
Avery had let you borrow her phone to play games, did she not?
Yes, she did.
So you did indeed have her phone at one point at the mall before the murder, isn't that correct?
This was a good deal before the murder, but yes.
So when exactly did she hand you her phone?
We were at the Fry Shack and she allowed me to play a game on it, like you had said.
She handed you her phone before leaving with Taylor, is that correct?
Yes, she did, but I did give it back to her.
Do you know that Avery had lost her phone and had never found it?
I think I have heard that, yeah.
But you testified that Avery had texted you after regionals, correct?
Yes, I did.
So if Avery didn't have her phone, it would have been impossible for her to message you, wouldn't it have been?
She texted me after regional. She lost her. In my to my knowledge, she lost her phone the night before the murder. So she could have texted. She could have texted me any point between regionals and the night before the murder.
But it was in your testimony that you did receive a message from Avery, isn't that correct?
Yes, I did. This was before she lost her phone.
Thank you. No further questions, Your Honor.
Your Honor, you're muted.
Yeah, happens to me a lot. Any redirect?
No redirect, Your Honor. At this time, the prosecution rests.
Okay, thank you. And I didn't see this in the packet I was given. Are there any motions at this time, or are we doing halftime motions?
The defense has no motions at this time, Your Honor.
Okay, thank you. Does the defense have any witnesses?
Defense calls Avery Becker to the stand. Good afternoon. Could you please state and spell your name for the record?
Hello, my name is Avery Becker, Becker.
Now, Avery, I would like to ask you a couple of questions, if that's all right. Which school did you attend to during the time of the murder?
I attended Colorado High School.
And what grade were you in?
I was a senior.
Did you join any clubs or after-school activities while you attended Colorado High School?
No, I did. I joined mock trial, yes.
Did your mock trial club have any championships or anything related to that?
Yeah, we competed in both local and regional tournaments, and I usually perform pretty well in them.
And how long have you been on the mock trial team?
I was on the mock trial team for all 4 years of high school until the very end of my senior year.
Do you have any specialty in mock trial, considering the fact that you were on the team for about 4 years?
Yeah, I really specialized in crosses and closings. That was definitely my favorite part, yeah.
Do you know of anyone who could have disagreed with that statement if someone were to disagree?
Yes, I mean, sometimes people have different styles, you know, and people disagree. I think Alex kind of disagreed earlier already, and then my former coach might have disagreed with that.
All right, moving on. Could you please state to the jury as to why you are here today?
Yeah, I'm here because I'm being blamed for a murder that I did not commit. And I'm here to help Coach Brackman, who was actually murdered, get justice.
You mentioned Mackenzie Brackman, the victim. How do you know Mr. Brackman?
He was my former mock trial coach.
And how is your relationship with him?
We had a pretty rocky relationship. I wouldn't say we actually got along pretty well.
Why didn't you get along?
That we definitely had different styles of just doing mock trial and doing things in general. We had a few like altercations too, just arguing.
Do you have any specific examples of a time you had an altercation?
Yeah, I mean, the first one I can think of that was a big deal is I actually got knocked down to the B team before regionals.
Did you try and do anything to get back on the team you were on before?
Yeah, I basically went to my friend Taylor, who was on the A team, and she was like, oh, I mean, I'm not really having a lot of fun with it if you're not there. So she moved back. She quit the team, and then I got back to go back on the A team.
Objection, Your Honor, hearsay.
Response?
I'll just move on.
Okay.
You mentioned Taylor Perkins. Would you please describe your relationship with Taylor?
Yeah, I was with her on the day of the murder, actually. She was like my best friend, you know, friends since the beginning of high school. Yeah, just my favorite person, probably.
So do you spend a lot of time with Taylor?
Yeah, pretty much, yes, yeah.
Were you with her the entire day when the murder occurred?
Yes, I was.
And what were you doing?
We were looking for my lost phone. Yeah.
How did you lose your phone?
Well, I'm not exactly sure how it was lost. I actually think it might have been stolen, but basically the day before, the last time I had seen it, we were at the Fry Shack with some other people.
Did you ever find your phone?
No, I have not found my phone.
All right. And circling back to Mackenzie Brackman, did you have any specific altercations with Brackman near the time of the murder that were particularly troubling?
Yeah, actually, really quickly, right before the murder, we had a pretty huge argument right after regionals.
And what were you arguing about?
Well, we do this thing, just for a little background, we do this thing after a tournament where we write on the board like what we do well and what we need to work on. So we were going to do that, and I went to go write, and he basically—
Your Honor, narrative.
I'm going to overrule that objection. The witness can continue.
He basically, I went to go write the stuff, and then he got really mad at me, and he basically was mad that I deviated from my original like pre-written closing in the trial, and he kind of insulted me and said that I didn't deserve to win and wouldn't do well at state.
How did you feel about him saying those things?
At the time, I was really embarrassed and upset because, you know, it was in front of my whole team after an entire day at a tournament. So I felt really bad about it, yeah.
So what did you do in response?
Well, I ran out of the room, and I ran outside, and I saw his car, and I realized I still had the marker in my hand that I was holding from writing the stuff on the board. And I saw his car, and I basically didn't think, and I just wrote worst attorney award on his car. And I realized later, well, like a few minutes later, that it was a permanent marker and not a dry erase one.
How did you communicate with your coach, Mackenzie Brackman, regarding the incident?
Well, he basically walked out and saw me, and then he kicked me off the team. So I went home and I was really upset, but I talked to my mom, and she kind of like let me know that at this point he was, you know, justified, because obviously, you know. And so I went to him in his office, and I also, but he wasn't there. So I sent a text basically saying that I would get a summer job to try to pay for it, that I would do everything that I could.
I'm sorry, counsel?
Objection, Your Honor, narrative.
Response?
Your Honor, my witness is simply testifying what she did after the incident.
Okay, if we can maybe break it up just a little bit with some follow-up questions.
All
right.
Thank you.
I was one sentence. I just texted him and also said that I would see if I could clean it, and that's all.
Okay. And what were your morals after Mackenzie Brackman had found the damage done to his car?
I at the time I didn't feel bad, but later after I talked to my mom, I felt pretty bad about it because, you know, it's a Porsche.
All right. Next, I'd like to discuss your affiliations with someone involved in this case. Are you familiar with Alex Fuentes?
Yes, I am.
And how are you familiar with Alex Fuentes?
He is just a kid on my mock trial team.
What were your feelings towards Fuentes?
I didn't like him that much, but I didn't know him super well. That's pretty much all.
During the 4 years in mock trial, how did your relationship with Fuentes grow or fall?
I would say they mostly fell because I think we were pretty friendly at the beginning, but, you know, we both kind of wanted the same parts and there was some conflict over that. So I would say fell.
How would you reach out to him if you ever needed anything regarding school, mock trial, or a serious situation such as this one?
Honestly, I'm not sure. I don't think I would really reach out to him. I would rather reach out to a lot of other people.
All right. Your Honor, permission to present my screen, which has previously been marked as Exhibit 14.
You may.
Can you see my screen?
Yes.
All right. Do you recall these messages?
I do not recall ever sending these messages, no.
What specifically do you or do you not recall about these messages?
I mean, I don't recall ever knowing where Brackman lived or texting Alex that I was going to go to Brackman's house.
All right. Lastly, going back, could you please specify as to why you would rather reach out to anyone rather than Alex Fuentes?
Honestly, just because I knew that he's always pretty jealous, and I would want to reach out to someone that I actually would have trusted. Yeah.
Thank you. Your Honor, I have no further questions.
Okay, thank you. Cross-examination?
Yes, Your Honor. Hi, Ms. Becker. How are you doing today?
Good.
All right, I'm just going to jump into the questioning. So you were on the mock trial team all 4 years at Colorado High School, correct?
Yes, I was.
And you were on the A team, correct?
Yes, for most of my time there.
And while you were on the team, you and Mr. Brackman didn't particularly get along, correct?
No, we didn't.
Was this because he thought you needed to work harder?
Not only that, but that was one of the reasons.
All right, because you were just a natural at mock trial, so you could just come up with stuff on the spot, as already stated in direct examination, correct?
Sure, yeah.
All right, so because of this, Brackman always criticized your work.
I would say he criticized my work because I didn't stick to his scripts.
All right, and Mr. Brackman liked you to be prepared with a script written out, as you already stated, correct?
Yes, he definitely liked everyone to have a script.
And you would go off script and say what came to you?
I would go off script when it didn't match the other teams. So I would, yes.
And in your opinion, which if you hadn't gone off script, you probably wouldn't have won all these awards, correct?
I didn't think Brackman's script was particularly well written. So I guess we don't really know, but I don't think so, no.
So did this kind of disobedience make you and Mr. Brackman argue a lot?
Yeah, yes, I would say so.
want to clarify one more thing before we move on. Your friend Taylor Perkins, is she also on the team with you?
Not anymore, no.
All right, so next question. About a month before the regional tournament, did Mr. Brackman bump you down to the B team?
Yes, he did, as stated in my direct.
All right, and you got your closest friend, Taylor Perkins, to quit just so you could be on the A team again, correct?
I would say it was both of us decision, and she also quit for other reasons, but yes.
All right, so then would you say that Ms. Perkins would do anything for you if you asked her to?
No, I do not think she would do actually anything for me.
All right, after regionals, then at a later mock trial meeting, you were assigned to write the pros and cons of the event on the board, as already stated on direct examination, correct?
Yes.
And at practice that same night, did Mr. Brackman start to criticize you and call you out in front of all your teammates?
Yes, he did.
He even told you that you wouldn't fare well at state, correct?
Yeah, yes, something along those lines. I don't remember the phrase.
Did you not storm out of practice after this happened?
Yeah, I ran out of the room really upset.
And then you took the permanent marker that was still in your hand and wrote "Worst Attorney Award" on Brackman's car, correct?
I thought it was a dry erase marker, but yes, I did.
All right, and it was after this moment that you were officially kicked off the team through a confrontation with Mr. Brackman?
Yes.
And then you later went home and told your mom that you were kicked off the team, but forgot to mention that you vandalized Brackman's car. Isn't that right?
Yeah. Yes.
All right. And as it states in your witness statement, you said you would get Brackman back if it was the last thing you did, correct?
In my witness statement, it says that I have said those words, but that was not an accurate representation of.
Right, but you still uttered those words, correct?
Yes, I've also uttered a lot of other things, but yes.
Okay, moving on. The day before Mr. Brackman's murder, being March 5th, did you go to the Fry Shack after school?
Yes.
With Miss Perkins?
Yes, she was there as well.
And while you were at the Fry Shack, you had your phone with you, right?
Yes, I did.
And as I recall, you went to the mall, correct?
Yes.
But not once did you realize your phone was missing?
No, we were just chatting about other stuff, so yeah.
All right, and then on March 6th, you ditched school just to go look for your phone, correct?
Yeah, we didn't have any important classes, so yeah.
With Taylor Perkins, your friend?
Yes, my best friend.
But she didn't even try to use her phone to locate yours, did she?
She has an Android, so.
All right, but you can still use Find My iPhone on Samsung.
We forgot that at the time. Yeah.
Okay. And just to recap everything that we've talked about today, even through other witnesses, you spontaneously and impulsively wrote on Mr. Brackman's car, correct?
Yes. Yeah.
And then you coincidentally lost your phone, one of the most important belongings to any teenagers, the day after the murder.
I lost my phone before
the day before the murder. That's my mistake.
Yeah, I lost my phone before the murder, yes.
And with your friend, Taylor Perkins, as your only witness to corroborate your alibi.
She was the only one that was at the mall, and I don't believe any of the mall people were interviewed about my whereabouts, so yes.
Right, but still, Taylor Perkins is the only one that can corroborate your alibi?
Yes.
All right, and just one last question. So when you were on Mr. Brackman's car, you felt bad, correct?
Later, yes.
But you couldn't fix it immediately, could you?
I couldn't fix it immediately. I was doing everything I could after, though. He wasn't replying, however.
All right. So just like when you murdered Mr. Brackman, you felt bad?
What? I did not murder Mr. Brackman, so no.
Right, no further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor.
Okay. May this witness be excused, or may the defendant step down.
Yes.
Okay. Does the defense have any other witnesses?
Yes, Your Honor. Defense would like to call Taylor Perkins to the stand.
Okay.
Can you introduce yourself for the record and spell your name for the record?
Yes, my name's Taylor Perkins, Perkins.
Would you please explain your relationship with the defendant?
Yeah, Avery is my best friend. We've been close all throughout high school.
And so you guys were so close, you would tell each other everything, crushes, drama, any troubles you're having?
Yeah, we told each other everything.
And what was Avery like whenever you interacted with her?
Avery was a really good friend. She's a super smart person, which is why she was so successful in mock trial. But overall, obviously, I love her a lot. She's always been very good to me and everybody else around her.
Did you do any clubs at your high school?
Yes, I participated in mock trial.
And what was that like for you?
It was pretty good. I joined the team because I got to spend more time with Avery. So that was my main reason for doing it. I would have probably rather just hung out with friends after school, but ultimately I'm glad I did it.
What was your relationship with Mackenzie Brackman?
You know, I didn't have a great relationship with Mackenzie Brackman, but we didn't really argue about anything. I just saw the way that he interacted with Avery, and I did find him to be a little bit too hard on her sometimes.
Did you witness any tension between Avery and Coach Brackman?
There was some tension just because they had a difference in how they liked to approach learning and presenting in front of people. Avery was somebody who liked to think on the fly because she thought it made her seem more genuine in competition. Mr. Brackman liked to be very prepared. So ultimately there is just a difference between their styles there.
When did tension start to occur between Coach Brackman and Avery?
There was always some tension, but Avery became very successful in mock trial, and that did seem to irk Coach Brackman a little bit more. So there was some tension around how prepared she was for practices before regionals and stuff like that.
Were you there the night that Avery was demoted?
Yes, I was there.
Okay. And were all the mock trial team members in contact with each other?
Mm-hmm. We have each other's phone numbers.
So after Avery was demoted, how did she react to that?
She was really sad because mock trial was a big part of her life, and she really wanted to get back on the team because she was a senior. This was her last opportunity to compete on the A team. So yeah, she was just disappointed about it.
What did you do after Avery was demoted off the team?
So when Avery was demoted from the team, I realized that it wasn't something that was going to be fun for me to participate in anymore because she was the reason I was there. Like, I don't want to be a lawyer when I'm older. I was just doing it for the experience and to be around my friends. So I decided to step down from the team. And a positive benefit of that was that Avery was able to go back on the A team. So it worked out for both of us.
Nice. So you were on the team during this, but how did Avery seem that night when Coach Brackman's car was vandalized?
She seemed really sad. She seemed disappointed in herself and her actions. And I think, she's expressed that to everybody.
Hearsay, Your Honor.
May I respond, Your Honor?
Response, please.
Avery has already testified in court to feeling this way, so Taylor can testify to this as well.
Any reply?
This is also speculation of Taylor Perkins on how Avery felt.
I'm going to overrule the objection. I think Ms. Jack can say how it appeared to her of how the defendant felt. I don't think it deals particularly with any statement, so it'll be overruled. Thank you,
then. And so do you know what Avery's consequences were after she was kicked off the mock trial team?
I think the main consequence was being kicked off a team, which was obviously something that was really painful to her considering the work that she put into mock trial and the talent she had. So I'd say that was the primary consequence.
Did you help Avery get back on the team?
Avery and I talked about things that she could do to get back on the team. And I suggested, you could text the people on the team and see if they can talk to Brackman. And I think she did end up doing that.
Who did you contact specifically?
I think that Avery reached out to a few members on the team, although she was the one communicating with them, not me.
Okay. Let's talk about someone else on the mock trial team. Alex Fuentes. What was your relationship with Alex?
So I didn't have a close relationship with Alex. I noticed that Alex sometimes seemed a little bit insincere, maybe a little bit jealous of Avery. And then the other thing is, Alex was always saying Avery was his best friend, which was always just a little bit strange to me because I know what my relationship is with Avery.
Okay. And did Alex have that kind of relationship with Avery?
No.
The night before the murder, where were you?
The night before the murder, Avery and I were at Fry Shack.
And what happened at the Fry Shack that night?
So we were at Fry Shack eating our meal, and then a bunch of members from the mock trial team came, which, was kind of upsetting for Avery to see, considering she had just been kicked off the team. But we just interacted with some of those people.
Was Alex there that night?
Yes, Alex was there.
And how was Alex acting to you and Avery?
Alex made some kind of condolences to Avery, I guess you could say, but Alex did seem kind of insincere. Alex played on Avery's phone. I remember that happening, but yeah.
Okay, so when you left, did Avery have her phone with her?
I don't think Avery had her phone on her.
Sorry, Your Honor, this is speculation of the witness.
Response?
I can just move on to the next question.
Okay, that objection will be sustained. Thank you.
Thank you, Your Honor.
So when did you notice the phone was missing?
Yeah, so I was texting Avery the next morning because she always drove me to school, and she wasn't replying to any of my texts. So when she picked me up, we realized that she didn't have her phone anymore.
So once you noticed her phone was missing, what did you do?
So we decided to retrace our steps. So we went back to the mall. We went back to Fry Shack to ask the employees there, did you see the phone? Did anything turn up? So yeah, and I was calling her phone many times that day, just so that we could maybe hear it as we were walking around the mall. We were just doing our best to be able to find it.
Do you know if there were any security cameras at the mall where you went?
I think so. I mean, there's always security cameras at malls.
Okay. And were you with your phone that day?
Yes, I was.
Okay. Were you and Avery together the entire time?
Yes, we were together the whole day.
Did you go any other places?
We were at the mall and we were at Fry Shack. So those are the places we were at.
Did anyone ever reach out to you, any detective, to ask about where you and Avery were that day?
No, and I would have been more than happy to speak with anybody. I didn't hear from anyone.
Okay. When did you hear that Coach Brackman had been killed?
I heard about it after I got back home from the Fry Shack.
Okay. Were you with Avery at that time?
I think I was, yeah.
Okay. Last question. Would you lie about this to save Avery?
I wouldn't lie in court for anybody or for any reason.
Okay. That will be all, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Perkins. I hope you are ready to answer some questions on this case.
Yeah, I am.
I would just like to say, please keep your answers short and concise. And first, starting off, you testified that you were Avery's best friend.
I am Avery's best friend.
And that you really valued her friendship.
I do value our friendship, yes.
And you only joined the team for Avery.
Yeah, I joined it because I wanted to spend more time with her.
You would do a lot of things for Avery.
Well, I do a lot of things for Avery, friendship-wise, but I would never do something unethical for Avery.
And Avery had some problems on the mock trial team.
Sorry, can you repeat the question?
That Coach Brackman and Avery had some problems on the mock trial team?
Yeah, they did. I think I just testified to that in the direct.
Yeah, and that Avery played some pranks on Coach Brackman as a way to deal with their feud.
She would sometimes, yep.
Yeah, and Avery got demoted to the B team because she was unprepared at practice?
Yeah, Coach Brackman did think she was unprepared.
So you thought Avery deserved to be on the A team, right?
Well, Avery did deserve to be on the A team because she was the best attorney, so yes.
So you decided to forfeit your spot so your friend could be on the A team?
That's actually not why I did it. I did it because I knew that I wasn't going to be able to see Avery anymore during practices.
Was that the end result of your decision?
That was the result, but you asked me why I did it.
And you heard about how Coach Brackman was critiquing Avery at practice.
Yeah, Coach Brackman would do that.
The day that Avery vandalized his car, correct?
Yeah, Coach Brackman said a few hurtful things to Avery that day.
But you only heard it through Avery's perspective?
You know, I know other people on the team, so I've heard from them as well.
You only heard it through other people's perspective?
No, I wasn't there, so.
So Avery decided the best thing to do in that situation was to write on his car with alleged whiteboard erase marker?
So that's not how I describe it. I don't think she just decided that was the best thing to do. I think she was upset, and she made a mistake that she regrets.
But you didn't see Avery do this.
No, like I said, I wasn't there.
So Avery could have just told you that she grabbed an erase marker and instead grabbed a permanent one?
Well, I believe Avery testified today as well. And I believe my friend, we tell each
Thank
other
you.
everything.
She said that she did this because she was angry at Coach Brackman for his statements and wanted to freak him out, right?
Yeah, she was angry about the statements that Brackman made.
And this did cause property damage and the paint was ruined on the car?
Yeah, I mean, I'm not saying it was a good thing to do. I think Avery agrees with that. It was clearly a mistake.
Yeah, so Avery thought that vandalism, a crime, was a good idea to get back at Coach for his statements?
No, it's not that Avery thought it was a good idea. It's that she made a
Is
mistake.
the end result of her decision?
Yeah, that was, but that wasn't what your question was.
So Coach Brackman kicked Avery off the team for this?
Yes, Coach Brackman did.
And it must have hurt her inflated ego that you said she had at times?
I feel like that's kind of two questions to ask, but it definitely did hurt Avery. Mock trial was a very important part of her life. So of course it hurt anybody who experienced something like that.
So you believe that Avery texted everybody on the team?
Yeah, Avery and I talked about it.
Even Alex Fuentes?
I think that she might have, but I wasn't the one texting, so.
But didn't Avery not get along with Alex?
No, they didn't really get along.
And would you call them friends?
I wouldn't call them friends necessarily from what I've seen of their relationship.
But Avery did get along with everybody else on the mock trial team?
Yeah, for the most part. I mean, we all knew each other pretty well.
And so you remember the day when Avery got kicked off the team, right?
Yeah, I wasn't there, but I've heard about it.
And did you guys went to the Fry Shack after that practice?
We did go to the Fry Shack, yes.
And unexpectedly, you met the rest of the mock trial team there.
Yep, we saw most of them.
And you guys talked about how unfair it was that Avery was kicked off the team?
Yeah, we did talk about that.
And you believe Alex was being insincere when he said that this was unfair?
Yeah, I mean, Alex clearly was being insincere, so.
And so Avery stormed off to the bathroom after this, right?
Yes, Avery did. She was really sad.
And you said in her direct that Alex played on her phone while Avery was in the bathroom?
Yes, Alex was playing games on Avery's phone.
And do you think she grabbed her phone after?
Probably not, because she lost it.
But she didn't grab her phone after Alex finished playing with it?
Probably not, because she lost it.
And do you fully remember if she grabbed her phone?
I think she clearly didn't grab her phone because.
But do you fully remember? Do you fully remember?
No, because if I remembered her grabbing her phone, then we probably wouldn't have lost it.
I would say that since Avery stormed off to the bathroom, she reacted pretty badly to this situation.
No, she didn't. It wasn't like out of anger. She was going to the bathroom because she was sad and she was emotional.
Was it out of frustration?
It was because she was sad.
And do you remember the day you went to look for Avery's phone?
Mm-hmm. I remember it quite clearly.
And you guys did school that day, right?
We did.
And so in the whole day, neither of you remembered you could use Find My iPhone to find Avery's phone?
I didn't know that until after the fact because I had an Android, so I assumed you can't.
Avery had an iPhone, correct?
Avery had an iPhone, but like I said, I had no idea that you could use Find Your iPhone. Sorry, can I?
Sorry,
Okay, guys.
Objection, Your Honor. Can the council
hold on a second. Guys, one at a time, you're talking over each other, and the truth is we can't hear either of you really well. So let's let the other person finish and we can go back and forth. Please continue.
May I finish my response?
Yes.
I was simply saying that neither of us had any idea that an Android could be used with Find Your iPhone, so we were doing what we knew we could do, which was call the phone.
And I asked, did Avery have an iPhone?
Avery did have an iPhone.
Okay. So going back to Avery's mock trial career, did she win a lot of awards?
Yeah, she was successful.
And when she got demoted, she did everything she could to get back on the team.
Yeah, she wanted to go apologize to Coach Brackman, but unfortunately she didn't get the opportunity to speak with him.
And she had a history of trying to scare Brackman since that car prank?
Sorry, a history of trying to scare Brackman? Is that what
With
you
her
said?
pranks? And since that car
She didn't have a history of trying to scare Brackman.
to freak him out, sorry, that's what I meant.
Okay, sure. I think the car incident freaked him out.
And she was
she had a
pretty
history.
rash in her decision to write on the car. It's just because she was angry, the light of the situation, right?
It was a rash decision, yeah.
Yeah, so she could have gone further than vandalism when he actually kicked her off the team.
No, she didn't.
Speculation.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor. Miss Perkins, would Avery text you if she ever needed anything from you?
Yeah, Avery would do that.
Okay. And how often would you guys text each other or see each other? Was it every day?
Yeah, basically.
Okay. And were you perceptive to Avery's feelings?
Yeah, I would say I was. I knew her really well and I've known her for a long time.
Okay. No further questions, Your Honor.
Okay, thank you. Anything based on that? Redirect.
A brief recross, Your Honor.
Limited to the redirect. Go ahead.
Okay. Okay, so during your just redirect in general, you said that you saw Alex on Avery's phone?
In my direct.
Let's say that in my redirect.
Sorry, in your direct.
Okay, so counsel, are you objecting that it's outside the scope of your redirect?
Yes.
Okay, so you can ask questions about, I think it was 2 questions that she asked, if you have anything about that, but you can't go outside that back to the first direct.
No, Your Honor, thank you.
Okay, thank you. May this witness be excused.
Yes, Your Honor.
Okay.
Good, I liked her.
Does the defense have any other witnesses?
Yes, Your Honor, the defense calls Blake Van Owen to the stand.
You may begin.
All right. Good afternoon, Professor Van Owen. Can you please state your name and spell your last name for the record?
Yes, Blake Van Owen, Vanowen.
Thank you. Let's begin by talking about your experience in law enforcement. How did you begin your career?
I joined the Aurora Police Department in 2005.
How long were you on the police force?
I worked for the police department for 9 months between 2005 and 2006.
So why did you leave the police force?
I was involved in an incident in which I injured a young woman of color during her arrest. I was officially cleared of wrongdoing, and the technique I used to arrest her was approved. However, I have never fully cleared myself of wrongdoing. I wish I had known then what I know now. The incident made me realize that I disagreed with a lot of police practices, so I left the force in favor of a career that focused on checking police power.
And when did this incident occur?
In 2006, over 15 years ago.
And what do you do for a living after leaving the force?
After leaving the force, I worked as a school resource officer, a private security guard, and then went into private investigation. Since 2015, I've also started teaching a class on police procedures at the Community College of the Rockies, obtained a master's degree in criminal justice, and have taught a course at CU Denver in police practices and social justice.
Have you ever testified as an expert courtroom witness in your career?
Yes, I've testified as an expert in 25 cases, including crime scene reconstruction 8 times, cell tower analysis 5 times, and in general police investigation tactics 12 times. I've also consulted on over 100 cases and have been accepted as a defense expert in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and in the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
And in which areas have you testified as an expert witness before?
I avail myself as an expert in police practices, the use of force, false arrests, forensic evidence, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
All right, Your Honor, the defense moves to enter Professor Blake Van Owen as an expert in crime scene reconstruction, police investigation tactics, cell tower analysis, and forensic evidence.
Ms. McDonald? Any objection?
Yes, Your Honor, may I conduct a brief ordeal?
You may.
I'm so sorry, Your Honor. I'm having difficulty with my internet, so I just want to let you know
We can tell, but
before I get started.
yeah, go ahead, and hopefully we'll keep our fingers crossed.
You were only a police less than a year, correct?
I'm sorry, could you repeat the question?
No worries. You were only a police officer for less than a year, correct?
Correct.
Because of an incident in which you injured someone during an arrest?
Yes.
And you also previously mentioned that you never cleared yourself of any wrongdoing.
Yes, I never cleared myself, but officially and legally I was cleared of all wrongdoing.
Correct. So this was in 2005 that you were a police officer, right?
Yes.
And that was
Correct,
16.
yeah, between 2005 and 2006.
And that was about 16 years ago then, right?
Yes.
Your Honor, at this time, due to Ms. Van Owen's record has only been a police officer in 2005, I would like to limit the scope of her expertise from without the consideration of police practices, seeing as how she hasn't been a police in 16 years.
You're muted, Your Honor.
Trying to make sure I wasn't using any unnecessary bandwidth. Any response?
Yes, Your Honor. Since becoming a police officer, the witness has been an expert in the area of criminal justice by being a school resource officer, a private security guard, and a private investigator. They're definitely an expert in police practices, despite not being a police officer physically. They have a career in police investigation tactics.
And the area you're asking her to be certified as an expert in?
Yes, Your Honor, police investigation tactics. The witness's entire career is focused on analyzing police investigation tactics as they've testified.
Okay, thank you. I'm going to overrule the objection. I find you don't need to be a police officer to be able to critique police or talk about their tactics.
Yes.
The jury will give it what weight it deems fit. So overruled. Thank you.
May I proceed?
Please.
All right. So let's discuss your analysis of Kyle Cusack's findings. Are you aware of Cusack's conclusions?
Yes, I am, and I agree that the evidence points to an intruder who broke into Mr. Brackman's home. However, I take issue with Cusack's narrative of how the crime occurred.
So what are Cusack's conclusions?
Cusack opines, without support, that upon entering Brackman's home, the intruder was surprised by Brackman and stabbed Brackman after gaining control of a knife that Brackman obtained from his knife block, or the knife drawer. I take issue with the assumption of a struggle.
So what specifically do you take issue with in the conclusion of a struggle?
There is no evidence of a struggle. The only evidence is supposed scuffing on the floor, but we don't know when these marks were made. Those marks could have been made on the floor before the incident. Markowitz and Cusack simply cut a corner and assumed that they were the result of a struggle, again with no evidence.
And are you aware of Cusack's investigation into the murder weapon?
Yes. Cusack also assumes that the murder weapon came from Brackman's kitchen, but acknowledges that it's a completely different brand.
And why do you take issue with that conclusion?
The murder weapon was completely inconsistent with the style and dimensions of all of the other knives in the kitchen. This leads me to believe that the knife didn't come from the victim's kitchen, but was instead taken to the crime scene by the perpetrator. Cusack just made the most simplistic assumption without taking into account the evidence.
So why is the situation leading up to Mr. Brackman being killed significant in this case?
Yes, so this means that the intruder would have been expecting Brackman, because the intruder broke into Brackman's home with the intention of killing him.
And are you aware of any other evidence that Markowitz discovered at the crime scene?
Yes, Markowitz also claims to have seen blood spatters at the crime scene. However, they managed to lose all pictures of the spatter in the hallway, an apparent cast-off on the wall near the front door. The file containing this amazing evidence was mysteriously corrupted, which I find is an indicator of utter incompetence in this investigation.
All right, so let's talk about the cell tower opinions from Detective Markowitz. Did you analyze Detective Markowitz's cell tower analysis?
Yes, Markowitz attempts to claim that Avery's cell phone was near Brackman's house at the time of the murder based on cell records. However, that is far from saying that Avery was near the house.
So why do you take issue with the conclusion that Markowitz's conclusion that Avery was near the house?
Well, there is overwhelming evidence that Avery lost her phone the day before the murder, which was confirmed by Taylor Perkins, again further corroborating Avery's alibi. Even so, cell tower information is nowhere near an indicator of location.
Why can't cell tower information indicate someone's location?
Cell tower data isn't remotely similar to GPS information. Cell phones are able to communicate across large areas, even up to 100 square miles. Also, cell phones can connect to farther towers if the nearest towers are busy. It isn't unusual for a single phone to get 5 calls and connect to 5 different towers.
And are you aware of any other cell phone records that Markowitz investigated?
No, Markowitz only investigated Avery's cell phone records, yet another corner cut. Markowitz did not look at Taylor Perkins' cell tower information or anyone else's in the area. It just shows that Markowitz already had his mind made up.
And did you investigate the records that Markowitz obtained any further?
Yes.
What did this investigation reveal about Avery's location?
As you can see in Exhibits 15 and 16, the records show that for each of the calls and texts involving Avery's phone, there is a corresponding call or text from Taylor's phone. Antenna 2 also covers them all, so the records are entirely consistent with Becker and Perkins calling and texting Becker's phone to try to find it as they retrace their steps. Antenna 3 also covers the Freisheck, again, aligning with Avery's alibi.
And are you aware of the police's investigation into Alex Fuentes' phone?
Yes.
What did the police's investigation involve?
The police simply accepted screenshots of the messages, but never actually investigated the contents of the actual phone. They have the tools to do so, including a forensic software called Celebrite that Markowitz themselves claims to be an expert on and even used in this investigation.
Objection, Your Honor, this is hearsay.
May I respond?
Please.
The witness has not testified to any out-of-court statement offered for the truth of the matter asserted. There's no hearsay in the witness's testimony. I'm not sure what counsel is referring to.
Reply.
Your Honor, the witness is referring to findings made by Detective Markowitz at this time, and these findings cannot be cited by the witness because they did not make these findings themselves.
May I respond?
No, I appreciate that, but I think the findings were made in open court, and I think defense has the ability to contradict those findings with another opinion, which is what we're doing now. So that'll be overruled, but thank you. Please continue.
So did you investigate these screenshots any further?
Yeah, so the issue with these screenshots is that the screenshots of a smartphone can be doctored very easily, and these screenshots were clearly doctored. In the top left corner of the screenshots, there's a label showing that Fuentes had used an app called Text Me.
Objection, Your Honor, this is actually outside of the scope of the case packet.
May I respond?
Please.
Your Honor, this is in the witness's statement. It's written verbatim in the statement. I can point you to the lines if you'd like me to.
Ms. McDonald, do we need to go to the lines, or where are we at?
Your Honor, the changes were made to the exhibits around January, removing this piece of evidence, and therefore it cannot be used today in court when looking at the exhibit. I'm also unsure of which lines counsel is referring to, and I was fairly certain that those lines were changed.
Your Honor.
Okay, Ms. Cook.
Your Honor, the evidence that was admitted has the words "text me" on it. I'm asking the witness to refer to those. When the prosecution admitted this exhibit, it was the old version that had not been updated. That was what was shared on the screen.
Can someone share their screen and show me what was admitted, please?
Yes, Your Honor. Could you give me 1 second?
Well, yeah, I don't care who does it, but.
I also have the exhibit pulled up if you'd like me to share it, Your Honor.
Whichever is easier, whichever is quicker.
Your Honor, the exhibit being shown on the screen was not what was entered into evidence during the examination of Alex Fuentes.
So this is, and I can't move it. I'm sorry. I looked at it quickly as it was scrolling. It didn't show what I think you think it shows. Would that be correct?
Your Honor, may I share my screen to present Exhibit 14? Oh, I just did, sorry. Is that all right?
Yes.
Your Honor,
And
the evidence that was admitted shows this text me in the corner. That is what's being disputed. The evidence that was admitted by the prosecution contained this. I understand that there's an updated version of the case that does not contain this, but that isn't what was entered into evidence.
so it's your position that the text me was what was put into evidence?
Yes, Your
Is that
Honor.
correct?
Yes.
Ms. McDonald, is the text me of what was put into evidence?
I don't believe so, Your Honor. And the jury also, during preliminary matters, was instructed to look at the most recent case packet and therefore wouldn't even have access to these records.
Okay. I don't have multiple copies, and certainly not the history that the parties do when it comes to the exhibit or what was recent or what was old. At this point, who do we have a copy of what was admitted?
This was admitted during the direct examination of Alex Fuentes. I'm not sure which opposing counsel actually
I'm
showed.
guessing that was Ms. McDonald because she did the direct of Mr. Cifuentes.
Yes,
right?
Your Honor.
Can you show me what you did as Exhibit 19, what you admitted?
Yes, Your Honor. And I'm so sorry for this confusion.
Okay.
I believe my co-counsel also shared this, but it was again the messages in which there is no text me in the upper left corner.
Okay. I can't, let's go back to the, okay. I can't know what was done at the time. In real court, we would have a piece of paper that we could all look at and come to an agreement on, but I'm going to take counsel's word or the prosecutor's word of what they admitted didn't have it. Again, I don't know anything about versions or the history of the case, so I'm going to sustain the objection and ask defense to continue with their direct examination. Thank you.
So what did your investigation of the screenshots conclude?
Well, yes. So as I said before, the issue with the screenshots is that screenshots on a smartphone can be easily doctored, and the screenshots that Markowitz accepted were just screenshots of the messages provided by a teenager that could easily be doctored and should not be accepted as evidence.
All right. And did your investigation lead you to any other suspects?
Yes, Blair Rollins, another student at CHS.
And why did you investigate Blair Rollins?
Blair Rollins had a strong and clear motive to kill Mr. Brackman. Brackman represented Blair's father, Jonathan Rollins, in court. Jonathan ended up being sentenced to life in prison. I discovered a recording from the trial that resulted in Jonathan's conviction and that points to a strong motive.
And how would you describe Jonathan Rollins' demeanor in this recording?
It's chilling. Jonathan is clearly extremely angry.
Speculation.
May I respond? Your Honor, I'm asking for the witness's interpretation of the recording. I'm not asking them to speculate as to the feelings of Jonathan Rollins, just their observation of his demeanor.
Any reply?
Your Honor, then I would ask co-counsel to rephrase the question, because I do believe that the question and the answer begun to involve speculation. It's the jury's decision as to whether or not to how Mr. Rollins conducted himself at this hearing.
Ms. Cook, are you planning on admitting this clip?
Yes, Your Honor. And I believe my question was, how would you describe Jonathan Rollins' demeanor? So I don't believe it calls for any speculation.
Well, I'm going to sustain the objection, and I think the jury can make what they will of the clip one way or another, since it's being admitted anyway. That's the best evidence of it.
All right.
Thank you.
Your Honor, may I share my screen to display what has been previously marked as Exhibit 22?
You may.
All right. Do you recognize this?
Yes.
How do you recognize this?
It's a copy of the recording that I obtained of Jonathan Rollins after Jonathan was sentenced in court.
And is it a fair and accurate representation of the recording you found?
Yes, it is.
Your Honor, the defense moves to enter Exhibit 22 into evidence.
Any objection?
Yes, Your Honor, this is hearsay.
May I respond?
Please.
This falls under the excited utterance exception to hearsay in Rule 803.2. The statement was made by Jonathan Rollins while he was under the stress of receiving his life sentence.
Any reply?
Your Honor, I don't believe that the proper foundation has been laid to include this piece of evidence within that hearsay exception.
And Ms. Cook, you said Jonathan Rollins.
Yes, Your Honor.
That was the client getting the life sentence, right?
Yes, Your Honor. And I did lay the foundation that they had been just given a life sentence.
Okay. The objection will be overruled and the evidence will be admitted.
Thank you,
Yes,
Your Honor. Is it all right if I play the recording for the court at this time?
Please.
I'll get you back, Bretman. It's the last thing I do.
Was everyone able to hear that?
I was, so I assume everybody else was.
Okay, great. And Your Honor, or sorry, Professor Van Owens, how does Blair Rollins relate to this?
Well, Blair was present at the trial and spoke on Jonathan's behalf at one point.
And would Blair have the opportunity to commit this crime?
Yes, Blair also went to Colorado High School and was a senior last year. Blair has the same build and body shape as Avery, and she essentially disappeared after the graduation. She was also absent from school on the day of the murder. Also, as aforementioned, Blair was friends with Alex Cifuentes. Given that Markowitz blindly accepted Cifuentes' screenshots, it's very possible that Cifuentes took Avery's phone and gave it to Blair to implicate her. After all, Rollins and Cifuentes were very close friends. It's also possible that Blair simply found Avery's phone and used it to implicate her. Not investing this clear suspect is a great example of the messy, incomplete investigation performed by the prosecution.
Thank you, Professor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Van Owen. So you believe that Mrs. Kuzak and Detective Markowitz came to an easy conclusion in today's trial, correct?
Yes, through assumption and just skipping certain steps that should have been taken in this
So don't you think
investigation.
that the easy conclusion can be correct sometimes?
In some cases, yes. However, a thorough investigation involves investigating all leads.
Yes. I'm so sorry, Ms. Van Owen. These will mostly require just yes or no answers. Did you come to your conclusions based off of the findings of Detective Markowitz and Kyle Kuzak?
After a thorough investigation, yes.
Sorry, but you referred to all of the same evidence that they presented today in court, correct? That they presented today in court, correct?
Yes, I did it. Yes.
And were you able to view the crime scene in today's trial?
I was not, but this is not my role in the case.
Also, but were you able to question any of your own suspects?
Again, that's not my role in the case as a private investigator.
Well, your case is crime scene investigation. Your expertise in this case is crime scene investigation, correct?
Again, I'm a private investigator.
But you were admitted today as an expert in crime scene investigation, correct?
Yes, as I have testified as it in court over 8 times.
So you didn't view the crime scene in total today?
Actually asked and answered.
Overruled.
Would you like me to repeat the question?
Yes.
So you weren't able to view the crime scene in today's trial?
I was not.
And you weren't able to were you able to question potentially Jonathan Rollins?
I was not able to question Jonathan Rollins as he is serving life in prison.
Right, and you weren't able to contact Miss Blair Rollins, correct?
Again, this is not my role as a defense private investigator.
Mm-hmm. But you weren't able to conduct your full expert capacity in today's trial by investigating the crime, correct?
No, I was able to fully investigate this crime, and again, the burden of the defense is to prove beyond a reasonable doubt.
Right, but you weren't able to measure the knives found in Mr. Brackman's home, correct?
I was not. However, the knife does not match any of the...
couldn't verify whether or not the knife matched any of the other knives, correct? You could.
I can, based on the exhibits provided in this case.
Well, you could only look at a few pictures, correct?
The pictures that are being used in this case as evidence, yes, of the knife block and the knife drawer. There are no other pictures in this case of the knives.
You weren't able to actually compare the knives to other knives found in the home of Mr. Brackman.
I would say that being able to view the knife and view the knives that Mr. Brackman owned would be comparing them.
Mm-hmm. So, according to the pay that you received in today's trial, you only worked 31 hours in this investigation, correct?
Yes.
That's less than the minimum of 40 hours most general jobs and positions have, correct?
I mean, again, I conducted a thorough investigation and found the evidence that I decided that I needed to testify in court today.
A thorough investigation in 31 hours?
Well, as you can clearly see, the evidence that I've provided in my direct examination is enough to show that Avery did not commit this crime.
But you didn't collect any of this evidence yourself, correct?
Again, as a private investigator on the defense, I am testifying on evidence that was provided by Markowitz and Cusack. So no, I did not specifically go to the crime scene and take these pictures. However, I viewed them and made my investigation based on this information.
My understanding of private investigators is that they investigate the crimes they've been hired to investigate, correct?
Okay. Let's slow down a little bit because we're starting to get over each other and we can't hear anything. What was the objection?
Improper cross.
Can you expand on that a little bit?
Yes, Your Honor. The counsel is currently testifying about their understanding of private investigation practices. That's improper cross.
My assumption is it will end in a question that you'll be presenting to the witness, right, Ms. McDonald?
Yes, Your Honor. I'm so sorry, my internet is cutting out. So
we're like getting close to the ninth inning here, so let's just keep going the best we can. Okay.
Yes, Your Honor.
Please proceed.
Mm-hmm. So my understanding of a private investigator is that you're hired to investigate the crimes. Aren't you hired to investigate crimes?
Yes, I am a private investigator. I'm not sure what you're asking.
But you didn't collect any of the evidence yourself.
Again, it was not. Was there an objection?
I objected to asked and answered. This question.
I'm going to sustain that. I believe it was asked and answered.
Yes, Your Honor. And you were only brought in and hired by the defense in today's trial, correct?
As a defense private investigator, I am hired by the defense. I'm not sure what you're asking.
Well, you were hired after the theories of Detective Markowitz and Kyle Cusack were presented to you.
Correct. Again, that is my role as a defense private investigator.
So you were only hired simply to rebut the theories presented by Detective Markowitz and Kyle Cusack in today's trial.
Yes, again, that is my role as a private investigator for the defense who is proving beyond a reasonable doubt that Avery did not commit this crime.
So sorry, that cut out a little bit. I just wanted a yes or no. You were only brought in to rebut the theories presented by Detective Markowitz and Kyle Cusack. That was your only job.
Yes, along with conducting my own investigation. So no.
But you didn't collect any materials?
Sorry, could you repeat the question?
But you didn't collect your own materials.
Well, I investigated other suspects again, like Blair Rollins, and I looked into the data that was
You
provided.
didn't question those suspects, correct?
And asked and answered.
Sustained.
So just to clarify though, you didn't bring in any of your own evidence today to rebut the
Objection,
theory.
asked and answered.
Response?
Your Honor, I'm trying to clarify to the jury as well as myself, just because my internet is cutting out.
It's actually, I don't think it's as bad as you think it is. We're
Oh, I'm so sorry.
hearing everything pretty well. It gets a little glitchy, but it's really not that bad. So I think that was asked and answered. I'm going to sustain the objection.
Okay, I have no further questions, Your Honor.
Thank you. Any redirect?
No redirect, Your Honor.
I'm sorry?
No redirect, Your Honor.
Okay. May this witness be excused.
Yes.
Does the defense have any other witnesses?
No, Your Honor. At this time, the defense rests.
Okay. Are the parties ready to proceed to closing?
Yes, Your Honor.
We'll obviously start with the prosecution.
Yes, Your Honor. And just to confirm, I do have the ability to reserve some of my time for the rebuttal, correct?
You do. It's my understanding anytime you don't use can be used as rebuttal. Is there any dispute? Is there any objection to that from the defense?
No objection, Your Honor.
Okay. I will trust your timekeepers will keep track of that stuff. If there is a problem, let me know.
Thank you, Your Honor.
Please proceed.
May it please the court, opposing counsel, members of the jury. I'd like you to think about fact and fiction. What have you learned today that is fact and what is fiction? To clarify, I don't mean convoluted, multifaceted theories presented to you by the defense in today's trial, but a reasonable story that has evidence. Let's start at the beginning. Mr. Brockman was coldly murdered on March 6, 2020. His body was found bloodied by his door, his kitchen in disarray with scuff marks and a broken plate. There's video footage of an intruder, masked and attempting to enter his home before finally opening the back door and entering the home with the intention to commit some act of criminal mischief. There are no disputes to these facts that we've entered in today's trial. There's no dispute to what happened. It is simply a matter of who. Let's take another step backwards. Avery Becker was a talented mock trial student, award-winning with a bright future ahead of her. But she let anger and fury and emotion cloud her judgment. She decided to exact her revenge. After being removed from her mock trial team by Mr. Brockman, she graffitied his car with worst attorney, an act that could be likened to, well, for today's purposes, a stab in the back. But we know that Avery wanted to do much worse. After being officially removed from the mock trial competition, she texted her friend, Alex Fuentes, that she intended to break into Mr. Brockman's home and trash it. Avery Becker wrote, "That will show him." My co-counsel and I have the burden of proof in today's trial, and we must prove two crimes and their subsequent elements. Avery Becker intended to commit a crime on March 6th. The proof that she did can be found in those text messages. That's not the only evidence we presented in today's trial. I'd like to walk you through the exhibits included in today's trial in conjunction with the charges levied against Avery Becker. That the defendant in Colorado on March 6th knowingly entered unlawfully into the home of Mr. Mackenzie Brockman with the intention to commit a crime therein, and that Ms. Becker, in the course of a crime of second-degree burglary, caused the death of Mackenzie Brockman. We have video footage of an intruder of Becker's height and build demonstrating her entering the home unlawfully with mask on, showing that she intended to commit a crime. And we have evidence of the open knife drawer, a struggle with scuff marks and a broken plate. We also have a map demonstrating the route from Ms. Becker's home to the home of Mr. Brockman with Becker's cell phone information. The defense is about to tell you a tall tale of imaginary doubts and what-if scenarios, and I urge you not to concede to them. Reasonable doubt is defined as doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence, not a story of mere possibilities. They will tell you a fiction of false facts and data, misconstruing the evidence and misconstruing the evidence entered today. The defense claims that my experts cut corners, but they fail to recognize that while most things aren't clear, in some cases like this one, it is. There are no holes or gaps in the story, as the defense would like to believe. It's straightforward and fact-based. On the other hand, the defense have tried to insert complexity into something quite simple and meticulous and pristine. They've tried to cloud the evidence with what if this, what if that. Let me tell you, there would have been an awful lot of coincidences for the defense's hypotheticals to actually be true. Blake Van Owen recited to you coincidence after coincidence, as she was hired to do. She misinterpreted the same evidence we brought to you today with a flurry of alternative theories with little experience. There's no reality to the assumptions Van Owen presented today. She didn't even collect any evidence herself. The only alibi presented for Avery was provided by her best friend, Taylor Perkins. Tell me, what would you do for your friend? Lie and protect them? I think Taylor would. She called Avery her favorite person. However, our experts in today's trial provided you two perspectives and two of the same theories. Our lay witness verified Avery's anger about her coach and need for revenge. The defense is going to stand up and tell you that our case is like a circle. I take that as a compliment. Circles are the perfect shape, all of its infinite sides equidistant from the center. No matter what angle you look at it, circles are the same. Such is our case. I urge you to consider these facts versus fables and come back with a verdict of guilty on the charges of first-degree murder and second-degree burglary. Thank you.
Thank you, Ms. McDonald. For the defense?
Yes, Your Honor. Your Honor and members of the jury, the prosecution's theory of this case may have started as a square, as a blank canvas, but it has cut so many corners that it's now a circle, nothing but a hole. Overall, despite butting heads, my client, Avery Becker, testified that she had a positive relationship with Mackenzie Brackman, one that she was invested in preserving. After making the mistake of marking Mr. Brackman's car, Avery was intent on apologizing and making amends, even offering to get a summer job to pay for the new paint. She may not have been the perfect student, but Avery loved being on the mock trial team and wanted more than anything to be reinstated. Grabbing the wrong marker is a long way off from murder and burglary. The prosecution's only other reason to believe that Avery had any intent to commit an act of vandalism were the screenshots sent to Detective Markowitz from Alex Cifuentes, purportedly displaying a text conversation in which Avery said she'd commit vandalism. However, you heard from Detective Markowitz himself that she only reviewed the screenshots from Cifuentes' phone and never actually downloaded the contents, meaning that Detective Markowitz has no way of being sure that these texts were from Avery. Not only did Avery have no motive, but she also didn't even have the opportunity. Today, you heard from Taylor Perkins, who testified that she was with Avery at the time of the break-in and murder. Taylor and Avery were tracing their steps all day at the mall and the Fry Shack, looking for Avery's phone, which was lost the day before. However, Detective Markowitz cut this corner as well and never investigated this alibi whatsoever, failing to interview any witnesses at the mall or the Fry Shack. The prosecution attempts to claim to know Avery's whereabouts at the time of the murder based on cell phone towers, but besides there being overwhelming evidence to support that Avery didn't even have her phone at this time, Professor Van Owen has explained today that cell tower data is not remotely analogous to GPS information. It's not accurate to track the location of a cellular device, so we don't actually know that the cell phone was even near Mr. Brackman's home. Furthermore, even if we are to assume that the cell phone had connected to the nearest tower, the particular tower near the victim's residence covers an extremely wide area. Detective Markowitz's conclusion that Avery was near the crime scene cut so many corners that it no longer resembles something even close to the truth. Detective Markowitz also failed to properly investigate the murder weapon, a central element of the prosecution's theory of the crime. Although Markowitz testified that the knife came from the crime scene, it doesn't match any of the other knives in Brackman's kitchen. This implies that whoever perpetrated this crime brought the knife to the crime scene with the intent to kill Mr. Brackman, rather than picking it up from Mr. Brackman's kitchen. The prosecution agrees that Avery had no motive to kill her mock trial coach. Therefore, whoever brought the knife to the crime scene, it could not have been Avery. Professor Van Owen has also shown you several holes in the prosecution's theory of how the murder actually occurred, that the prosecution literally ignores. The prosecution claims that there was evidence of a struggle at the crime scene, but their only actual evidence is some scuffing on the floor. But they have not shown you that this scuffing was the result of a struggle, as it could have been on the floor prior to the crime. Valuable items had been left undisturbed. There were scissors in the chair next to where Mr. Brackman was sitting. He would have grabbed the nearest sharpest thing to him if he could see the perpetrator coming. This is all consistent with the truth that the perpetrator of this crime came to Mr. Brackman's home with the sole intention of murdering Brackman, which the prosecution agrees could not have been my client. Overall, what every piece of evidence in this trial is culminated to is that Blair Rowlands, not Avery Becker, is the perpetrator of this tragic crime. Blair Rowlands' father, Jonathan Rowlands, was a former client of Mr. Brackman's who ended up being convicted of murder and sentenced to life in prison. We've shown you a chilling audio recording of Jonathan Rowlands yelling out that Brackman was going to die for sending him to prison. This is a significant motive for murder, which the perpetrator of this crime possessed. Blair Rowlands also attended Colorado High School, is the same build as Avery, and was absent from school that day, and has since disappeared. Today, the burden of proof is on the prosecution. At the beginning of trial, my co-counsel asked you a question. She asked, how can the prosecution prove, beyond a reasonable doubt, that Avery was the one who broke into Mr. Brackman's home and killed him? At the end of the trial, the prosecution has shown you that they cannot. Throughout their assumptive logic, incomplete investigation, and general corner cutting, you've seen how this investigation has turned into a circle. Counsel has tried to explain how a circle is a good thing because you can look at it, it'll be the same from all angles. But clearly it's not, as you've heard Professor Van Owen's testimony. Furthermore, we're using this as a metaphor to demonstrate the utter holes in the prosecution's theory that have sowed significant seeds of doubt throughout this entire trial. Therefore, we ask you, the jury, to find Avery Becker not guilty of second-degree murder, or of second-degree burglary and first-degree murder. Thank you.
Thank you, counsel.
Your Honor, could I ask for a brief time check before I move into my rebuttal?
You may.
Defense has exactly 30 seconds on the clock for closing.
Thank you.
Sorry, not defense, I meant prosecution.
Think about who you were in high school. The stakes felt so high. With college around the corner, jobs, and future prospects, the idea of someone tarnishing your perfect record seemed terrifying. Everything was black and white, right and wrong, life and death. The burden of proof is upon us. There's overwhelming evidence in our favor. Look at the exhibits we entered in today's trial. There was a complete investigation by Marquis and Fuzak. They testified to it. We're not saying that every high schooler is prepared to commit murder, but Avery Becker was. She knew what she was doing when she vandalized Mr. Brackman's vehicle, and she knew what was she doing when she killed him. Thank you.
Thank you, Ms. McDonald. I'm sure as you guys have had this before, the scoring panelists need to complete their stuff. So what I would ask is everybody hang out for a couple minutes and let them finish. Scoring panelists, what I'm hoping, if you can finish everything you need to do, and then turn on your camera so I know you're done and ready to go. Good job, guys. Thank you.
Hi, everyone. I'm waiting to hear from Ashley to make sure she received your guys' time cards or scores cards. Sorry. Give me 1 second.
And I think there were 4 judges, 4 judges scoring, if memory serves. There we go. Okay. Let's make sure they get them, and then we can start talking.
I'm still waiting to hear back from Ashley, but you guys can give your feedback while we're waiting if you'd like.
Okay, thank you. So I guess I'd ask if everyone could turn on their cameras, because I feel like mine has been on for a long time. And I don't really have whatever order you guys want. If you guys want to, the scoring panelists want to introduce yourself and give a couple remarks to everybody.
I'll go ahead and start. My name's Elizabeth. You guys did fantastic. I'll tell you a little bit about myself. I'm a prosecutor. I have been for my entire career. I spent 6 years up at the district attorney's office in Fort Collins. And now I'm a prosecutor for the city of Thornton. Been doing that for about 3 years. The first thing is, this is such a weird platform now that we're all on Zoom. So I think you all did an excellent job of kind of being flexible to that and to kind of changing things as you go based on, this kind of platform. So good job there. I'm going to kind of just go through, like, I'm very where this began and where it ended. And so I apologize if I don't use your first names or if I used your character name. I was just kind of taking notes as I go. I think the openings were great. I did sort of notice that folks were reading, it seemed a little bit scripted, and that did change for those individuals who did the opening statements. That changed as the trial went on. Maria, I noticed that you did do some voir dire questions, and actually I know that there was another student who did the same. Fantastic job on that. I think that was a good opportunity to kind of question the witness a little bit more, and the reason that you did it was fantastic. So I thought those students who did voir dire I think it was for expert witnesses, did a good job on that. To all of the individuals who were playing a role or playing a character, I think you guys were totally believable. So good job there. I also like, Nicole, there was a time that there was an objection that you actually just kind of paused for a second and said, can you go ahead and just say that objection again, just so you could prepare your response? That's good. It showed that you were engaged and that you were listening and that you were going to be responding to that objection. And so that's totally okay, is to kind of like slow down a little bit and say, hold on a second, what was that again? And prepare your thoughts and then to respond. There was a lot of, these were some difficult witnesses, I think. All of the panelists would probably say that. And so you just got to be careful about like talking over the witness. You got to let them respond, because ultimately, when that did occur, they usually gave you what you wanted them to say. So just kind of giving them an opportunity to finish would be my advice. I'm just going through my notes here. Let's see here. I thought that Annie, you were very calm, and Maria, I would say the same thing for you in terms of your questioning, just really calm in your questions. They were very concise and to the point. I liked that there was a couple objections that were drawn, and the individual who was directing the witness would just say, you know what, that's fine. I'm not going to craft a response to that. That wasn't what I expected the witness to say, so I'm going to move on. So overall, guys, I think you did a fantastic job, a lot of hard work, and it was very evident, and congrats.
Okay, thank you. Brenda, your mic is live. You want to go next?
Okay. I've been a paralegal for over 40 years, so, and I've done a lot of litigation and trial work, but I was very impressed with everybody's performances. One of the main things that was difficult for me is that several of the students talked a little too fast, like they were talking to their friends. And in a presentation like this, you have to slow it down a little bit so that you're enunciating correctly and people can understand what you're actually saying. But most of I thought the questions were great. Also in when you're speaking, if you're speaking too fast, you don't tend to pause as often as you should when you're going from one sentence to another. So sometimes, you don't know where that break should be. So that would help. All of the characters were really good. There's a lot of confidence with everybody. And then also just remembering to speak a little louder and enunciate and speak clearly. But overall, I thought everybody did a very good job, and I was really super impressed. Just really exciting. So, and like Alex was very expressive and very passionate, and I loved that. That was great. And I thought all of the characters were very, very believable. So I enjoyed that. It was really good.
Thank you. Miranda?
Hi, my name is Miranda. I'm a paralegal as well. I've been a family law and divorce paralegal for about 10 years. I'm also in my final year of law school at Syracuse Law School out of New York. I was incredibly impressed with all of you, and I enjoyed it way more than I honestly anticipated. So good job to you all. I did think at the beginning it seemed like a few of you were reading a bit more or referring to notes a little bit more, but I thought that everybody really gained confidence as you went forward. Ms. Cook, I thought that your professionalism was really exemplary. I really appreciated the way that you addressed the judge. You always said, may I? I thought that was just incredibly done. So good job. Also, Ms. McDonald, I thought you did fantastic. And even with some minor technical difficulties, I thought it was great. All of you were fantastic. Ms. Jack, I thought you did a really great job not getting flustered by difficult questions. I think that in real life, someone testifying on behalf of their friend might get more emotional. And so I thought that you did a fantastic job, just in your presentation overall. Everybody, honestly, I was so impressed. You could tell how hard you guys worked. And I think that if you guys decide to move forward in the legal field, that you all have a very, very bright future.
Thank you. Lee?
Yeah, thanks. So just to give you kind of my background and perspective, I've practiced law for about 30 years. The last 10 of which I've actually been in-house as a general counsel. Before that, when I was in private practice, I actually was an expert witness in a lot of cases, but never actually got to do what you guys do, which is the actual litigation. So I know how hard it is to be an expert witness when you're getting crossed. And I would say not just the expert witnesses, but all of you as witnesses did a really nice job. And I guess my only suggestion just generally is it's okay sometimes to say yes and to try not to guess where they're leading you down a path. Answer the question that they're asking you. And it felt like that there was sometimes that there was a little bit more of a battle to get to an answer that either the jury or the opposing counsel knew exactly where they were taking you. But I would say overall, just amazed at how great you guys did and just how well. I'll echo what everyone else said. The witnesses to me, you all came across as very credible, knowing your role and very believable. I really liked on the prosecution side. It felt like there was certainly great passion and emotion, and that's what you need to have as prosecutors. And that came through, I think, both in the opening and the closing really well. On the flip side, I think the defense did a really nice job of staying even keeled, and we're just here to pull out the facts and let the jury make the determination. So that also landed really well. I think the objections, one of the hardest things on an objection, I think, is not making the objection or replying to the objection, but actually then having to answer to when your opponent replies. And again, I would say on both sides, to the extent that we got and you got an opportunity to reply back, that thinking on your feet really came through clearly, and advancing kind of a counter to the point that was made. So again, really thought that was well done by both teams. So yeah, just echo what everyone else has said. Just you guys obviously have put a lot of time and effort into this. You know the case so well. You know the roles so well, and just really glad that I got to participate, because I came away just incredibly impressed with the talent you all brought to the table.
Thank you. I totally agree. I agree with what everyone said. You guys did really, really well. And if you like it, keep doing it. That's the way you get good at it, the way you get better at it, because you're already pretty solid. My name's Matt Wenig. I am a Chief Deputy District Attorney in Denver. I am currently in charge of the gang unit. I've been a DA for about 24 years. So trying to prove cases beyond a reasonable doubt is what I've done my whole career. This was a hard case. There is no doubt about it. I think it was hard for both sides. You guys kept me jumping a good bit with a lot of the objections. I thought were really well placed. You know, some of them I'm like, well, if I do that, this witness doesn't get to testify, so I kind of have to let it. But you guys, your knowledge and your responses were spot on. You know, there are a couple things that I would kind of caution you for. In a closing, somebody said, I think. You can't say your personal feelings. You know, it's spatter and not splatter and things like that. But to be honest, you guys, I do this for the law schools too. And I put you guys up against any one of those teams that I see in the law school. I think you did really, really well. And it was a pleasure doing that. So thank you guys. Any questions or anything before we break? I don't know. Is our host is still here? Or are we?
Yep, we have all of your scorecards, so you guys are good to go.
Okay.
Well done, you guys. Thank you so much.
Yeah, thank you.
Thank you so much to the panel and to you, Judge. It was a great round. Thanks, everyone.
Yeah, thank you.
Thank you.
Thank you.